I die on a Tuesday in October, in a studio apartment in Jersey City, at 53 years old, and the first thing I notice is that I die alone. The apartment is on the fourth floor of a building that was once something, and is now simply adequate. The carpet is the color of old cream. The radiator knocks twice every hour at intervals I have memorized without trying to memorize them. There are 3 framed prints on the wall: a Hopper reproduction, a botanical diagram of an iris, a photograph of the Hudson at dusk that I bought from a street vendor on a Sunday when I was feeling something I could not name. And I remember in the final moments thinking that these 3 things together constitute a life I had not intended to arrange. I am sitting in the chair by the window. The chair is beige and tilted slightly to the left, which I compensate for by sitting slightly to the right, a small adjustment I have been making for 6 years without ever thinking to fix the chair. Through the window, the Hudson. It is October, and the light on the water is the particular gray gold of late afternoon in the northeastern fall, the kind of light that makes you believe for exactly one moment that things can still be beautiful. My left arm begins hurting. I think. Tension. I think. I need to eat something. I think I will call the building super about the chair tomorrow. The pain moves. It is not shoulder tension pain. It is a different kind of thing entirely, a pressure that starts at the sternum and radiates outward in a way that I recognize from somewhere deep in the part of my brain that is still animal, still paying attention to the body's signals when the mind has long since stopped. I press my right hand to my chest. The pressure does not stop. It becomes, in the space of 30 seconds, the only thing there is. My phone is on the side table 2 feet away. I reach for it, and my arm does not cooperate. The Hopper reproduction blurs. The botanical iris. The Hudson at dusk. I think the filing was a disaster. I think Sandra Hewitt knew exactly what she was doing. I think Gregory. And then the chair and the light and the carpet the color of old cream are not there anymore, and I am not there anymore, and for a period of time that I will never be able to measure, there is nothing at all. What comes next is not the nothing continuing. What comes next is smell first, the particular combination of cedar and whatever Gregory used on his leather shoes, the smell of the West Village townhouse that I identified as home for 12 years before I understood what home can do to you when it decides to stop being yours. The smell is so specific and so immediate that my first thought is not rebirth, not miracle, not impossible. My first thought is, I am dreaming of the house. Then the light. Morning light, winter trending, coming through the curtains we had ordered from a place on Bleecker Street. The curtains are linen, pale silver blue, and they move slightly with the heat from the radiator. Not the knocking radiator in Jersey City, a different one, a newer one, a radiator that has never needed to be apologized for. I am lying in bed. The bed is ours, was ours. The ceiling above me is the ceiling of the West Village townhouse. The water stain in the upper left corner, the one Gregory kept meaning to fix, is still there, still the shape of something I could never quite determine. A question mark. A reaching hand. I stare at it for a long time. My left arm does not hurt. I bring my hand up in front of my face and I study it. The skin is tighter than I remember it being in the apartment in Jersey City. The knuckles are different. There is a small scar on my right index finger from where I cut myself opening a wine box at a work event in November of the year I turned 38, and the scar is there, and it is fresh looking rather than old. And I understand, with the particular calmness of someone who has already been through the worst of a thing, that I am 38 years old, and that it is not October. I sit up. The clock on Gregory's side of the bed reads 6:47 a.m. On the nightstand, his reading glasses, a biography of some Federal Reserve chairman, a glass of water that has not been touched. Gregory is not in the bed. Gregory is already up, already somewhere in the house, already moving through the rooms in the way he moves through rooms, efficiently, quietly, taking up exactly as much space as he intends to take up and not 1 square inch more. My phone is on my nightstand. I pick it up. The date is April 7. I know this date. I know it because in the first life, April 7 was 6 weeks before May 20. May 20 was the day Sandra Hewitt filed the divorce petition in the wrong county. 6 weeks before that filing, I was here in this bed, in this house, with no idea that the attorney I had hired to protect me had already received 11 referral checks from Vance Kellerman LLP, Gregory's firm, totaling $240,000 over 14 months. I am back. The thought arrives not with drama, but with the specific quality of cold certainty that I have come to recognize as the only reliable emotion. Cold certainty is not hope. It is not rage. It is a calculation running itself behind the eyes, taking in the variables, the date, the timeline, the names, the documents I now know exist, and arriving at a number. The number is 42 days. I have 42 days before May 20. 42 days to do the thing I did not know to do in the first life. 42 days to change everything. I get out of bed. The floor is the same floor, the wide plank oak that Gregory had refinished in the 6th year of the marriage. The year we renovated the 3rd floor, and I chose the stain color from 17 samples, and he said, "Whichever you want," and meant it. I stand on the floor in my bare feet and feel its temperature and its solidity, and I breathe. I move to the window. Outside, the West Village Street is doing what it does on early April mornings. Delivery trucks, the coffee shop 2 doors down opening its green awning, a man walking a large gray dog with the expression of someone who has not yet had coffee but is philosophically at peace with this. The street is familiar. The street is in its way evidence that I am where I believe I am. I stand at the window for exactly 6 minutes. Then I go to the bathroom. I look at my face in the mirror. 38. The lines are lighter. The shadows under my eyes are from the ordinary tiredness of someone who went to bed a little late, not the tiredness of someone who has been carrying the weight of a settlement she did not understand for 15 years. I brush my teeth. I wash my face. I think about Katherine Chen. Katherine Chen, whose card I had seen once, 2 weeks after the settlement, in a bar association newsletter that my new attorney, the one I finally hired in my 50s too late for an appeal that went nowhere, had left on the table. Katherine Chen, whose name had been in an article about a Manhattan divorce case 3 years after mine, a case in which she had uncovered nominee accounts in shell LLC structures so precisely designed to evade marital estate disclosure that the judge used the word fraud in the final order. Katherine Chen, who the article mentioned in a single parenthetical, had previously consulted for Vance and Kellerman. Previously consulted for Vance and Kellerman, which meant that Gregory's firm had brought her in at some point, which meant that she had a conflict of interest clause, which meant that if I retained Katherine Chen, before Gregory's firm remembered to, before Gregory thought to protect himself with that specific move, he could not use her. I am 38 years old, and it is April 7, and I have 42 days. I know what I need to do with them. Downstairs, I hear the sound of Gregory making coffee. The particular rhythm of him, the cabinet, the drawer, the measured pour, is as familiar to me as the radiator in the Jersey City apartment, and it carries the same quality of a thing that has been memorized without intention, absorbed into the body over years of proximity. I know his rhythms. I know exactly how he moves in this house, and he has no idea that I know what he did. He has no idea that I know about the February 12 email. He has no idea that I know about Alder Point Holdings. He has no idea that I have already watched him win, and that I have already watched everything that winning cost me, and that I am standing in this bathroom at 38 years old, with 15 years of subsequent knowledge inside my body like a second skeleton, holding me upright. I dry my hands on the towel. I fold it back the way I always fold it, in thirds over the bar the way he prefers it. I go downstairs. Gregory is in the kitchen, in the gray sweater he always wears on weekday mornings when he is working from home, standing at the counter with his back to me. He is tall and he takes up space in a way that always felt, when I loved him, like the good kind of solidness, reliable architecture, a thing you could lean against. Now, in the kitchen light, with what I know inside me, he looks exactly like what he is. A man in his early 40s who has already decided how the next 12 months are going to go, who has already called Warren Alden, who has already sat in the corner office at Vance and Kellerman and mapped the strategy with the kind of methodical care that he brought to everything, and who has no idea that the woman standing in the doorway behind him knows every move. Morning, he says, without turning around. He pours the second cup, sets it on the counter near the window where I always drink it. The small domestic choreography of a marriage that is, as of 3 weeks ago, quietly ending. Morning, I say. My voice is steady. I am proud of this. I take the coffee and I stand at the window and I look at the street and I think, Katherine Chen has an office on Park Avenue South. Her firm, Chen Feynman Associates, specializes in high net worth divorce and forensic asset tracing. She has been practicing for 11 years. Her retainer is $4,500. I have 42 days and $4,500 and 15 years of accumulated knowledge about exactly what happened to me and exactly who made it happen. I drink the coffee. The morning begins. I should explain Gregory, because to understand what happened in the first life, you need to understand what made the betrayal so precisely designed, and that requires understanding the man who designed it. I met Gregory Vance at a bar association mixer in the spring I turned 26. I was there because a colleague of mine was being honored for something, and I was being a good friend, which meant standing near the bar with a glass of white wine, nodding at intervals, and trying not to look like someone who found these events fundamentally exhausting. Gregory was there because Vance and Kellerman had co-sponsored the event, which was a thing Gregory's firm did regularly. Sponsoring things, having their name on things, appearing at the edges of every professional function in Manhattan, with the quiet purposefulness of an organization that understood that presence is a form of power. He came to stand near me at the bar, not at me near me, that specific proximity of someone who is confident enough not to need an approach. He ordered scotch. He was wearing a suit that cost more than my monthly rent, which I recognized not because I knew suits, but because I had been around enough of them to know the particular way expensive fabric moves. He was 31, 5 years older than me, with the kind of face that improved in direct proportion to how long you looked at it. Not immediately handsome, but assembling into something more than that under sustained observation. We talked for 2 hours. He was funny, which surprised me. He was sharp about his own profession in a way that suggested self-awareness rather than ego. He asked me questions and he listened to the answers, which sounds like a low bar and was not and still is not, because most people in rooms like that one are waiting for their turn to talk. We went out the following Saturday. Then the Saturday after that. Then the Saturdays stopped being a formal structure and became simply, we were together. I have spent considerable time, over the 15 years since the settlement, trying to locate the moment when the man I married became the man who hired Sandra Hewitt to represent me while she was receiving referral fees from his firm. I don't believe there was a single moment. I believe it was more like a slow turning, the way a body of water turns in seasons, the surface appearing the same, the deep current shifting without announcement. I want to give you specific years, because abstractions are not the same as truth. In the 4th year of the marriage, I had a difficult quarter at MedAxis, a campaign I had led, one I had pushed for internally, defended through 2 rounds of budget review, shaped over 8 months, failed at launch. Not catastrophically, not in a way that ended careers, but clearly enough that the post-mortem meetings had the specific quality of professional air being let out of a room. I was 31 years old, and I had invested more of myself in that campaign than was perhaps advisable, and the failure had the weight that failures have when you have made the mistake of wanting something very much. Gregory took me to dinner at a restaurant I loved, the Italian place on Bleecker, on a Thursday night when I had not asked to go, and he had made the reservation without telling me. We ordered too much food, which was characteristic of him. He always ordered as if there were more people at the table than there were, and he talked about the campaign not as a failure but as a data set. What worked, what didn't, what I had established as fact about the market, even if the campaign hadn't converted. He was not consoling me. He was not performing comfort. He was thinking through it with me as a colleague thinks through a problem, with genuine interest in the analysis. By the time we walked home, I had stopped feeling like someone who had failed, and had started feeling like someone who had learned something expensive. That is a real thing he did. That was a real evening. I want to hold on to this because the February 5 email cannot be the whole story, and I refuse to make it so. In the 7th year, Gregory's father died in the spring. He did not handle it the way I expected him to handle it. I had known him to be controlled, measured, strategic, and his father's death broke through that in a way that startled me. He cried in the car, coming back from the hospital, in the way that people cry when they have been holding something very tightly and the hold finally gives. I drove. I did not say anything, because I had learned enough about him by then to know that he did not need words in that moment. That presence was the thing, and talking would be the wrong kind of presence. We drove through Queens in the dark, and he cried, and I drove, and I held his hand when he could reach across. He held on to that. He told me 3 months later that it had mattered to him, that I had known not to speak. He said, I didn't know you knew me that well. I said, I've been paying attention. He laughed, and the laugh had something relieved in it, the quality of a person discovering that they are known and finding it not frightening, but a relief. That is also real. I carry both of these, the restaurant and the car, because they are the truth of the marriage alongside everything else, and making the marriage only a deception requires me to lie about what I actually lived through, which I am not willing to do. What I know factually is this: Gregory was always strategic. This was one of the things I admired about him. He thought in structures and contingencies in a way that his clients paid very well for, and in the early years of the marriage, I experienced his strategic intelligence as something directed outward, at his cases, his career, his measured accumulation of influence within the firm. He became a partner at 36, which was not unusual for Vance and Kellerman, but was not usual either. He cultivated relationships with care, not cold-bloodedly, but with the consciousness of someone who understood that a professional life is built from people, not just from work. The marriage was good. I want to be accurate about this because it would be easier and also dishonest to retrospectively arrange the 12 years into a continuous narrative of manipulation and control. It wasn't that. There were years that were genuinely fine, even genuinely happy. We traveled well together. We disagreed in ways that mostly resolved themselves. He was not cruel. He did not, in the ordinary texture of married life, behave like a man who would later arrange to have his wife's legal representation compromised. What he was, underneath the intelligent conversation and the good suits and the particular skill with which he made people feel they were being listened to, was someone for whom winning was not optional. Not in a way he articulated, not in a way that could be pointed to and named in the years I was inside the marriage. But in retrospect, with the sediment of 15 years to sift through, the pattern is visible. He never lost anything that mattered to him without a consequence that fell on someone else. The junior associate who got credit for a brief Gregory had substantially written. The partner who was passed over for the committee seat Gregory wanted. Small things. Things that looked from the outside like ordinary competitive professional life. But they added up across 12 years into a portrait of a man who understood, at a cellular level, that losing was something that happened to other people. When I told him I wanted a separation on a Sunday morning in February, we were sitting at the kitchen table with coffee and the newspaper, which is such a domestic and mundane setting that I sometimes wonder, in retrospect, whether I chose it consciously or whether I was trying to make the announcement as ordinary as possible, as if the ordinaries of the setting could contain the blast radius. He was reading the business section. I said, "I think we need to separate." He looked up. His expression was not what I expected. Not shock, not grief, not the particular rawness I had imagined when I rehearsed this moment. It was something more controlled than that. Something measured. He said, "Is this a conversation or a decision?" I said, "I think it's a decision. I think I've been deciding for a while." He was quiet for what I counted, silently, as approximately 15 seconds. Then he folded the newspaper, the specific way he folded it in quarters, very precisely, and he said, "Okay, we should handle this carefully. Handle this carefully." That is what he said, and I heard it in the moment as evidence of his good character. Mature, practical, we are adults. We can do this without destruction. I did not hear it as a man who had already begun to calculate, who had already identified the nature of his exposure, who had within 2 days of that Sunday morning sent an email to his colleague Warren Alden with the subject line, "Preliminary Assessment of Exposure." But I know that now. I know about the email now. And I know about the call he made, within the first week, to Sandra Hewitt. Sandra Hewitt, whom he would recommend to me 3 weeks later as an excellent divorce attorney. Actually, I know her slightly, very solid, you should look her up. Said casually, said once, in a tone calibrated to make the suggestion seem like a favor rather than an architecture. I looked her up. I hired her. In the first life. I need to tell you about the marriage more fully, because the betrayal only has its true weight against the reality of what was real and what was good. The first 3 years were the best of it, I think, not because nothing was complicated, but because everything that was complicated still felt navigable. We had moved into the townhouse on Charles Street when Gregory made partner, a splurge that felt at the time like an arrival. The house had 3 floors and a garden that was slightly too ambitious for our level of attention, but which we maintained, imperfectly, with the kind of optimism you bring to things in your 30s. I planted herbs in terracotta pots. They mostly died. We replaced them. This felt fine. My career was growing too, which mattered to me more than I always let on. I had come up through the marketing side of medical device manufacturing. Not glamorous, not the kind of work that gets written about, but real, substantive work. The kind where you spend years building something before you understand the shape of what you're building. I had risen to VP of marketing at Med Access by 36, which was the year Gregory made partner at Vance and Kellerman. And this symmetry, both of us advancing in the same year, both of us arriving somewhere we had been aiming for, felt at the time like evidence that we were on the same trajectory. We were not on the same trajectory. We were on parallel tracks that happened to be going at the same speed for a while. In the 10th year, we tried something. I say it this way because neither of us named it explicitly at the time. We did not sit down and say, "This is what we are doing and why." But we both understood without naming it that the marriage had thinned in the way that things thin under sustained inattention. And we made a set of adjustments, the way you make adjustments to a thing you are not yet willing to let go of. We started spending weekends at the East Hampton house more regularly. We made dinners that were not the efficient weeknight meals of 2 professionals managing parallel careers but deliberate meals. The kind where you open a specific bottle and cook something that takes 2 hours and does not photograph well but is very good. We read more books and occasionally read the same book, not as a project, but as the natural overlap of two people in the same house who had gotten back to paying attention to the things the other was carrying. These adjustments lasted about 14 months. They were not nothing. They improved things in real and measurable ways for a real and measurable period. And then the adjustments stopped because the underlying thing had not changed, and the effort of maintaining a corrective becomes, eventually, its own weight. You cannot indefinitely compensate for a structural issue through effort. The effort reveals the structure, which is almost worse. You can see when you are trying hard exactly where the trying is doing nothing. I was 36 when I understood, without having the specific words for it, that the marriage was moving toward an ending. Not immediately, not dramatically, but in the way of something whose center of gravity has shifted. I understood this in the body the way you understand things you're not ready to think about yet. A knowledge that sits at the periphery of awareness, available when you look at it directly and retreating when you look away. I was 36, and Gregory was 41, and we were managing two demanding careers and a large house and the complex social and professional ecosystem of two people at the level we were at, and it was easier to attribute the thinness to that than to look at the thinness directly. I looked at it directly, finally, in the February I was 38. Sunday morning, the kitchen table, the newspaper. I said, I think we need to separate. And he said very precisely, is this a conversation or a decision? I have thought about this question many times since, in both lives. The precision of it. The way it framed my announcement not as something that had happened, but as a classification problem. Was what I was saying an opening move or a concluded position? It was the question of a litigator, not the question of a husband. And I understood, in the instant of hearing it, that something about the way he received my announcement was not quite grief, not quite shock, but something more organized. I did not understand what I understood. It would take 15 more years of the first life and the February 5 email to give it its right name. The divergence was gradual. It is always gradual, which is why people don't catch it in real time. What I can say now, with the clarity of 15 years and the advantage of knowing how the story ends, is that the marriage began to hollow out around the time Gregory started being mentioned in the legal press more regularly. He had a run of high-profile divorce cases, high net worth contested, the kind that get written about. He was very good at them. And the particular skill he demonstrated in those cases, the forensic understanding of how assets could be hidden, moved, restructured, was a skill I did not register as significant information about my own position until it was too late. He knew every mechanism. He had seen every mechanism. He had, in the course of representing his clients, developed a comprehensive education in exactly how a person with significant assets could prevent a spouse from accessing them. And he had, at some point in the years between when I loved him fully and when I sat at the kitchen table on a February Sunday, made a decision about how to use that education. Not overtly, not dramatically. The restructuring was quiet. Alder Point Holdings LLC was registered in Delaware in the spring I turned 36, 2 years before I told him I wanted a separation. He listed himself as the manager and Warren Alden, his colleague and closest professional ally at the firm, as the registered agent. The Hamptons property, a house in East Hampton that we both knew existed, that I had been to 4 times, that had been in my mind an asset of the marriage, was transferred to Alder Point Holdings in a transaction Gregory would later characterize as a business reorganization. The deferred compensation, $340,000 in unvested equity from a lateral move Gregory made in 2019, was structured in a way that technically made it a future asset rather than a current one, a distinction with significant consequences for marital estate calculations if you didn't know to subpoena the right documents. The nominee investment accounts, $620,000, managed through a private banking relationship that Gregory had established in his name alone, existed in a structure so opaque that it required a forensic accountant with specific experience in private banking concealment to identify them. Sandra Hewitt had no forensic accounting relationships. Sandra Hewitt had a general practice, a modest West Side office, and 14 months of referral fees from Vance and Kellerman. In the first life, I did not know any of this. I sat across from Sandra Hewitt in her beige office, and I told her about the marriage and the house and the assets I knew about, and she took notes and she nodded, and she charged me $350 an hour, and she filed the petition in the wrong county, which caused a 3-month procedural delay that pushed us past the deadline for subpoenaing premarital asset conversion records. She submitted an incomplete asset disclosure that listed the house on Charles Street, Gregory's current partnership income, and his retirement accounts as they appeared on the most recent tax return. She did not subpoena the Vance and Kellerman partnership agreements. She did not inquire about Alder Point Holdings. She did not retain a forensic accountant. She did not, in mediation, push back on the offer of 32%. She told me the offer was reasonable given the assets on the table. She told me that litigation would be expensive and uncertain. She told me that 32% was a fair settlement. The settlement she helped negotiate was 32% of the marital estate as Gregory's firm had chosen to define it. The actual marital estate, including the Hamptons LLC, the deferred compensation, the nominee accounts, was approximately $5.4 million. 32% of what was disclosed was $612,000. 32% of the actual total would have been over $1.7 million. The difference between what I received and what I should have received was more than $1 million. I lived 15 years in the absence of that $1 million. I lived in the studio in Jersey City, and I watched the Hudson from a beige chair, and I knew, without being able to prove it, that something had been done to me. I knew the way you know things in your body before you can name them: a weight, a wrongness, the particular exhaustion of someone who has been robbed with such precision that the robbery doesn't leave a mark you can show anyone. Now I am 38, and it is April 7, and I know exactly what was done to me, who did it, and how to stop it. I need to tell you about the February Sunday one more time, because I know now what I didn't know then. He folded the newspaper in quarters. He said, "Okay, we should handle this carefully." What I did not see, because I was watching his face and not the precise control of his hands, was that he put the newspaper down with the same deliberateness he brought to everything. Calibrated. Decided. 2 days later, he sent the email to Warren Alden. The email I will eventually read in Discovery in the Second Life, sitting in Katherine Chen's conference room on a Tuesday evening in November, has a subject line that reads, "Preliminary Assessment of Exposure." The body of the email, 6 short paragraphs, contains, in the third paragraph, a sentence I have memorized with the same involuntary precision with which I memorized the knocking radiator. She's still emotional from the conversation. I don't expect her to retain sophisticated counsel. If we move quickly on the HH recommendation, we control the process. OH. Sandra Hewitt. He had a name for her already. An abbreviation. He moved quickly as the email recommended, and within 2 weeks he had casually over dinner mentioned her as an excellent attorney. By the end of March, I had hired her. He controlled the process. In the first life, not in this one. In this one, I wake up on April 7 with the email in my memory and 42 days before the original filing date, and the specific knowledge that what needs to happen is not that I fight Sandra Hewitt after the fact. It's that I never hire Sandra Hewitt at all. What needs to happen is that I retain Katherine Chen before Gregory's firm can remember that she has a conflict clause. It needs to happen by April 28. That is the date I have decided on. 3 weeks out, enough time for Chen Feynman Associates to run their conflict check, complete their intake process, and begin building the case. 3 weeks of performing normalcy in this house, in this marriage, while the clock runs. I am very good at performing things. I have had, without meaning to acquire it, 15 years of practice. Let me tell you precisely what Sandra Hewitt did. Not what she claimed to do, not the version that appears in her invoices, but what she actually did and failed to do, because the specificity matters. The specificity is what I carry in my second life like a map of every wrong turn. Sandra Hewitt, Esq., maintained a solo practice at 218 West 70 Twin Street. She had passed the bar in 1994 and had been practicing family law for 23 years by the time she sat across from me in her office. She was, in the superficial respects that clients look for in attorneys without knowing what to look for, reassuring. She kept meticulous notes. She used the word "unfortunately" with the practiced compassion of someone who had learned that the word functions as insulation. She had a small bowl of candy on her desk, Werther's Originals, and I remember the bowl in particular because I found it inexplicably touching when I first sat down. A small detail that made her seem like a person rather than a professional. She charged $350 an hour. Over the course of the first life's proceedings, she billed me for 64 hours. The bills were itemized in the way bills are when there is something to hide in the itemization. Many small entries, each plausible on its own, adding up to a rhythm of activity that does not match the actual quality of the work. What she did. She filed the dissolution petition on May 20 in Kings County, rather than New York County. Gregory and I were legal residents of Manhattan. The case belonged in New York County. The Kings County filing required a corrective refiling that took 11 weeks, which pushed the case into August. August was, for reasons Sandra Hewitt appeared not to know or care about, significant. The New York statute of limitations for subpoenaing records related to premarital asset conversion runs from the filing date. By the time we refiled in New York County in early August, we were 86 days past the original May 20 date. The window to subpoena Alder Point Holdings formation documents and the records showing when and how the Hamptons property was transferred into it was effectively closed. What I know now, from the research I eventually did in my 50s with the attorney who took my appeal, is that this outcome was not accidental. The wrong county filing is a mistake that a family law attorney with 23 years of experience does not make by oversight. The correct county is determined by residence, and residence is determined by the client's address, which was on the intake form that Sandra Hewitt had reviewed and signed off on before filing. The Kings County filing was deliberate. It was the first domino in a sequence designed to limit the scope of discovery before it could surface Alder Point Holdings. What she failed to do: she did not subpoena Gregory's partnership agreements at Vance and Kellerman. The partnership agreements would have revealed the deferred compensation structure, the $340,000 in unvested equity, and more importantly, the structure of the firm's internal referral tracking system, which would have shown Sandra Hewitt's own name in the payment records 14 times over 14 months. She did not retain a forensic accountant. This alone, in a case involving a senior partner at a Manhattan corporate law firm with 15 years of knowledge of asset structuring, was malpractice on its face. The standard of care for high net worth divorce proceedings requires forensic accounting review when one spouse has access to sophisticated financial structures. Gregory had that access. Sandra Hewitt knew he had that access. She did not call a forensic accountant. She did not inquire about real property beyond the Charles Street house. There are standard interrogatory questions in New York divorce proceedings, standard questions in the discovery template, asking both parties to list all real property interests. The question was in the form. Sandra Hewitt submitted the form. Gregory's attorneys, Vance and Kellerman's family law division, representing him, a conflict of interest so brazen it still takes my breath away, responded to the interrogatory by listing only the Charles Street townhouse. They did not list the Hamptons house. The omission was, in any other proceeding with any other opposing attorney, the kind of gap that gets caught in the first round of review. Sandra Hewitt did not catch it. She did not conduct a deposition of Gregory. She cited cost and strategic considerations. She told me a deposition would antagonize him and make mediation harder. The deposition, which would have included sworn testimony about all real and personal property interests, would have created a perjury problem for Gregory if he failed to disclose the Hamptons house and the nominee accounts under oath. This was, of course, precisely why Sandra Hewitt did not pursue it. In mediation, she accepted the opposing counsel's framework. Warren Alden had prepared a financial summary that presented the marital estate as Gregory's partnership draw, the Charles Street house, and the retirement accounts. $12 million in total by this accounting. 32% of $12 million is $3,840,000. But the settlement was not based on $12 million. It was based on a revised number that incorporated, through a series of adjustments Sandra Hewitt did not challenge, the positions Gregory's attorneys advanced, that his future earnings potential should be calculated at a discount, that the house should be valued at its assessed value rather than its market value, that certain retirement structures were non-marital assets. The number that emerged from these adjustments was 1,900,000. 32% of 1,900,000 is 608,000. $608,000, and the right to live in a studio apartment in Jersey City, with a beige chair and a Hopper reproduction, and 15 years of certainty that something had been done to me. That is what Sandra Hewitt did. I want to tell you about the day the settlement was finalized in the first life, because it is the day everything became a fact rather than a feeling. It was a Tuesday in late October. I remember the light specifically, not the Hudson light, not the West Village morning light, but the flat midday light of Sandra Hewitt's West 72nd Street office, which had no east or west orientation that mattered, which was simply an interior space with overhead fluorescence, and the bowl of Werther's originals and the framed law school diploma, and the particular quiet of a professional office in which decisions of consequence are made and then filed. Sandra Hewitt had the documents prepared. She walked me through them with the specific patience of someone explaining a thing that does not require explanation, a thing that has already been decided by the time you sit down. Each page had a tab. She said, "This section covers the primary settlement terms." She said, "This section covers the asset disposition." She said, "If you'll initial here and sign at the bottom of page 11. I read each page. I am even now someone who reads every page of a document before signing, which is a characteristic that served me well in the second life and did me no good in the first, because the document I was reading was built on a foundation that I had no way to audit. The numbers were internally consistent. The percentages were calculated correctly from the disclosed estate. I read the numbers and I could not find an error in the document because the document was not where the error was. The error was in the estate it was based on. I signed on page 11. I initialed in 2 places. Sandra Hewitt countersigned as my attorney of record and notarized the documents with a stamp that she pressed down with the flat, efficient motion of someone who has done this many times. The stamp went down. The decision became a record. The record became the legal reality. She said, "I think this was the best outcome we could have achieved given the circumstances." I said, "Thank you for your work." I meant it. I believed her. I thanked a person who had cost me $1 million while receiving referral fees from the opposing party, and I thanked her sincerely, because I was 39 years old and I was sad and I did not know. I went outside, and the October air was cold and clear in the way of New York October, that particular crispness that always feels like the city has decided to be bracing about the change. And I stood on West 72nd Street for a moment, and I looked up at the sky, and I thought, that's done. And then I walked to the subway. That's done. That's what I thought. Not, something is wrong. Not, I need another opinion. Not, the number on page 11 should be 3 times higher than the number on page 11. I thought, that's done. I spent 15 years understanding, by degrees, that that's done was the wrong response to a document I should have challenged. In a proceeding I should have fought, with representation I should have questioned from the moment. Gregory mentioned Sandra Hewitt's name at dinner, in a tone calibrated to sound like a favor. There is something I need to tell you about the referral fees, because the referral fees are what transform the story from malpractice into something that has a different name. In New York, under the rules of professional conduct, an attorney must disclose to a client any financial relationship with adverse parties or with entities connected to adverse parties. The rule exists because the financial relationship creates a conflict of interest. The attorney's ability to represent the client zealously is compromised when the attorney is receiving money from the other side. Sandra Hewitt received 14 referral checks from Vance and Kellerman over 14 months. The total, $240,000. These were not payments for legal work on behalf of Vance and Kellerman's clients. These were structured as referral fees, compensation for sending personal injury and probate clients to a boutique firm that Vance and Kellerman maintained a cross-referral relationship with. But the relationship was administered through the Vance and Kellerman accounts payable system, and Sandra Hewitt's firm appeared in their vendor records. She did not disclose this to me. There is a word for what Sandra Hewitt did: fraud. There is a more specific phrase: attorney misconduct. There is a regulatory body, the Attorney Grievance Committee, First Judicial Department for attorneys practicing in Manhattan, that is interested in this kind of thing. In the first life, I never had the evidence to bring a complete complaint. I knew something was wrong. I hired the attorney who took the appeal, and she was thorough, but we were limited by what had happened. The case was settled. The window for reopening was narrow. The records we needed were in Vance and Kellerman's vendor system, and accessing that system required a subpoena, that required a proceeding, that required evidence sufficient to reopen a settled case. It was circular. It was a door with no handle on the outside. In the second life, I don't need to reopen anything. In the second life, I start fresh with the knowledge of exactly what is in those records and with an attorney, Katherine Chen, who has the specific experience and the forensic accounting relationships to surface every one of them. Katherine Chen had previously consulted for Vance and Kellerman on a tax-related matter in 2019. The consultation had been limited in scope: 2 meetings, a written analysis, no ongoing engagement, but it had created a conflict entry in Chen Feynman Associates' conflict database. Under New York ethics rules, a firm that has provided any consultation to a party must be screened from adverse representation of parties in matters that are substantially related. Substantially related. A divorce case against Gregory Vance, whose partnership income and asset structure had been the subject of the 2019 consultation, would meet the substantial relationship threshold. Chen Feynman's conflict check would identify the entry. The firm would be conflicted out from representing Gregory, but the conflict ran both ways. If I retained Chen Feynman first, if I signed the retainer agreement and paid the initial fee before Gregory's team remembered to run a conflict check on Katherine Chen, then the firm was mine. And Gregory, having lost access to the attorney most qualified to find what was hidden in his financial structure, would need to find another expert. Someone less practiced. Someone who hadn't spent a decade doing exactly this kind of case. The question, in those first days after waking up in the townhouse, was timing. Gregory's email to Warren Alden on February 12 had said, "If we move quickly on the HH recommendation, we control the process." He had been thinking about Sandra Hewitt from the beginning. which meant he had not been thinking at that point about Katherine Chen. He had recommended Hewitt to me and I had hired her, and the case had proceeded without Chen's involvement. In the first life, Gregory had never needed to protect himself from Katherine Chen because I had never retained her. But if I hired her now, before he thought to protect himself with her conflict clause, then I would be the one controlling the process. I had 42 days. I was going to use 21 of them. I want to tell you one more thing about what Sandra did, because this piece of it lived in me the longest, not as anger, but as something quieter and harder to name. When the settlement was finalized, $608,000, no alimony, legal fees each party pays their own. Sandra Hewitt called me to go through the papers. We sat in her office, the Werther's originals in their bowl on the desk, and she walked me through the documents with the measured efficiency of someone explaining a thing that has already been decided. At the end of the call, she said, "I think this was the best outcome we could have achieved given the circumstances." I believed her, not because she was convincing, but because I had no evidence to the contrary, and because when you are inside a loss and the professional you've paid $350 an hour to guide you tells you the loss was inevitable, it is very difficult to locate the alternative reality. You take the number. You sign the papers. You move to Jersey City. I believed her for 15 years. And then one Tuesday evening, in a conference room that didn't exist yet in a second life I hadn't begun yet, I read an email that started with the words preliminary assessment of exposure, and I understood exactly what had been done to me. And the understanding was not a shock because I had suspected it for 15 years, but it was a kind of arrival, the moment when a thing you have known in your body finally has the right name. Sandra Hewitt cost me more than $1 million. She cost me the Hamptons house and the deferred compensation and the nominee accounts and the 5 years of alimony she should have fought for. She cost me the agency of understanding what was mine and having someone fight for it. She also cost me something harder to name, the version of the next 15 years where I wasn't carrying this. I carry it now in the second life, but differently. Not as weight, but as information, as the map. The first thing I have to do in the second life is not call Katherine Chen. The first thing I have to do is survive the next 3 weeks without Gregory noticing that I know things I shouldn't know. This is not a small task. Gregory is observant in the way that good litigators are observant, not openly watchful, but cataloging, storing, building a file on everything he sees. He has spent 12 years learning my rhythms, my tells, the specific quality of my silence when I am thinking, versus when I am worried, versus when I am angry. He knows that I am the kind of person who, when carrying something important, carries it in my shoulders. A slight elevation, a tension visible if you know where to look. I have to perform normal grief. The grief of a woman who has said she wants a separation and is now living in the complicated limbo of sharing a house with a man she is leaving. Day by day, in the ordinary texture of a relationship that has been formally acknowledged as ending, but has not yet ended. I know what normal grief looks like because I have lived it. I know the specific way the mornings feel when you are in the same house as someone you have decided to leave. The careful navigation around each other, the meals that are slightly too quiet, the way you say goodnight and it sounds like a different word. I know all of this from the first time. I perform it accurately. What I do not perform is the full interior of what I felt in the first life at this point, which was confused, sad, frightened, and starting to be suspicious without being able to articulate the suspicion. Those feelings were real. They were legitimate. They also left me vulnerable. What I feel now in the second life is almost nothing except the cold certainty. The cold certainty is a very useful feeling. It does not look like confidence, which would make Gregory suspicious, because it is below the surface, doing its work quietly, in the way that a foundation holds up a structure, without the structure being aware of what's happening beneath it. April 8th, a Tuesday. I go to work. MedAxis is headquartered in a tower on 3rd Avenue, a glass building with a lobby that smells of recycled air, and the particular ambition of organizations that exist on the 43rd through 46th floors. I have been VP of marketing here for 2 years. My team is 11 people, organized into 3 functional groups, and I have spent those 2 years building the kind of department that can operate without my presence for a day, then a week, then longer, not because I plan to be absent, but because I have always believed that the measure of how well you've built something is whether it runs in your absence. I sit at my desk and I open my email and I do my work. I approve a campaign brief. I have a one-on-one with Jamie Ortega, my senior director, who is brilliant and slightly too competitive with the sales team, and who will, if I handle the next few months correctly, be ready to step into a VP role within 2 years. I go to a product review meeting. I eat lunch at my desk because I am thinking about something else. What I am thinking about is this: I need money. not a large amount. The retainer for Chen Feynman Associates is $4,500, and I have that. I have my own account, a savings account that Gregory has never had access to, that I have been maintaining as what I privately called my autonomy account since my mid-30s, a thing I did not examine too closely at the time, but that in retrospect suggests some part of me knew that the ground under the marriage was not entirely stable. The account has $12,000 in it, more than enough. But I also need money going forward, because the divorce proceedings, even with a better attorney, are not going to be free. Chen Feynman's hourly rate is much higher than Sandra Hewitt's. The forensic accountant will charge separately. There will be motions and hearings and document review. I am estimating, based on the complexity of what I know needs to surface, that my legal costs could reach $80,000 before the settlement. I make good money at MedAxis. My salary is $212,000 plus bonus. But I have to think about cash flow, about having accessible funds during a period when Gregory's attorneys will likely attempt to argue that my income alone is sufficient and that I don't need interim spousal support. I make a note. I will deal with this. I know how to deal with this. April 9, a Wednesday. Gregory and I eat dinner at the kitchen table, the way we always have, without ceremony. He has made pasta with the tomato sauce from the jar that he pretends is from the jar, but is actually modified with half an onion and a small amount of wine, a thing I noticed him doing in the second year of the marriage and never mentioned because I found it endearing. The kitchen smells of the sauce and the particular quality of the late April evening light coming through the west-facing windows. We talk about his day. One of his cases has a complication, a client who has refused to provide certain financial documents, which is creating discovery problems. He talks about this with the controlled frustration of a professional person managing an obstacle, and I listen, and I say the things I would say, and I watch his hands on his fork. He does not know what I know. He thinks he is being watched by a woman who is sad about the end of her marriage, and confused about what comes next. He thinks he has already managed the primary risk, which is the risk of capable legal representation. He thinks Sandra Hewitt is in her office on West 70 Twin Street, ready to receive my call. He is going to recommend her in approximately 11 days if the first life is any guide. He recommended her on April 19 the first time, an offhand mention over dinner, the specific calibration of casual, exactly once. He will not mention her again. He only needs to mention her once, because the once is enough. In 11 days, when he mentions her, I will say, actually, I've already retained someone. I am thinking about his face when he hears that. Not with malice, or not only with malice, but with the kind of focus that a person brings to a thing they have thought about very carefully. April 10 through April 14, 5 days of ordinary life. I go to work. I come home. Gregory and I orbit each other in the house with the particular careful courtesy of two people who have agreed to end something and are living in the agreement before it becomes official. There is no hostility. There is, if anything, too much civility, the politeness of people who know they will soon be strangers and are practicing the distance already. I have lunch with my friend Cora on Thursday. Cora has been my closest friend since graduate school, a friendship that survived both of our marriages, one of her divorces, 3 cross-country moves between us, and the particular entropy that takes most friendships by the mid-40s. She is the person I called, in the first life, from the studio apartment in Jersey City when the settlement was finalized. She said, I don't understand how that number is right. I said, neither do I. She said, you need to talk to another attorney. I said, I'm too tired. She let me be tired. In the second life, I am not tired. In the second life, I sit across from Cora at the restaurant near her office, where we have been having lunch every 2 to 3 weeks for 8 years, and I say, I'm moving forward with the separation. I've decided to look for representation. She says, what does that mean, look for? You don't have anyone yet? I say, I have a few names I'm going to look into. I want to find someone who really knows high net worth divorce. Someone with forensic experience. She looks at me for a moment. She says, that sounds like you've been doing research. I say, I've been doing some research. She nods. She does not ask why, and I am grateful for this, because Cora has always understood that there are things I carry carefully, and that the careful carrying should be respected until I'm ready to put them down. She recommends a name, a friend of a friend who had a good divorce, and I write it down and thank her and will not use it. I have my name already. April 14, Sunday. Gregory goes to the gym at 8 a.m., the way he does every Sunday. He has gone for 2 hours. The house is quiet. I sit at the kitchen table with my laptop, and I open it, and I search Chen Feynman Associates, and I read everything that is publicly available about Katherine Chen's practice, her past cases, her forensic accounting partners, her fee structure. What I find confirms what I already know. Katherine Chen is the right attorney. The question is not whether she is right. The question is whether I can get to her before anyone at Vance and Kellerman remembers to check. April 15 through April 20. 6 more days. On the 15th, I call Chen Feynman Associates from my office with the door closed. I speak with Katherine Chen's intake coordinator, a person named Marcus Trello, who has a measured professional voice and asks appropriate questions about the nature of my situation. I describe the situation accurately. Senior partner at a Manhattan firm, assets that may be complex, seeking representation in a dissolution proceeding. I say I want to schedule a consultation with Miss Chen specifically. I have heard she is the right person for cases with financial complexity. Marcus says Miss Chen typically has a 2-week wait for initial consultations. I can put you down for April 29. I say I understand she has a wait. I want to ask whether there is any possibility of an earlier appointment. I am prepared to be flexible on timing. I can come in during lunch, early morning, whatever works for her schedule. A pause. The sound of a schedule being checked. Marcus says I have a cancellation on April 22 at 2 p.m. Would that work? April 22 is a Monday, 7 days from now. I say, yes, that works. I give him my name and my contact information, and I pay the consultation deposit, $500 on my credit card, and I close my office door for another minute after the call to sit with the specific satisfaction of a thing being set in motion. On April 17, Gregory mentions Sandra Hewitt. He does it differently than I remember. In the first life, he waited until April 19. In this life, he does it 2 days earlier, which means something. Either the timeline has shifted slightly, or he is slightly more anxious than he was the first time, which would suggest that something in my behavior has created a minor variation in his. I file this observation away. It is a small thing, but it tells me he is watching. He says at dinner, I was thinking about the attorney situation. I know someone who might be useful. Sandra Hewitt, she's a family law specialist, very experienced. I can send you her information if you want. I say, thank you, but I've already been looking into a few people. I think I'm going to go with someone I've identified through my own research. He looks at me. His expression is controlled. He says, anyone I would know? I say, I don't think so. She does divorce and family law, forensic side of things. Not the Vance and Kellerman circle. He says, forensic side. That sounds complicated. I say, my understanding is that complex asset cases benefit from that approach. Since you have a partnership interest in various structures, it seemed prudent. He says, I don't think this has to be complicated, Mara. I say, I know you don't. I appreciate that. I'm just trying to be thorough. He nods. He eats his dinner. His expression has the quality of a calculation running. I eat my dinner. My expression is the expression of a woman who is being careful and practical, which is exactly what I am. I should tell you what the house feels like during these 3 weeks, because I have described the strategy, but not the texture, and the texture is where I live. The house is very large for 2 people who have decided to end their marriage. 3 floors the garden in the back, still optimistically planted, still imperfectly maintained, the last of the winter-cut perennials pushing up through the beds in the specific defiant way of plants that do not know or care what is happening inside the building above them. I find myself looking at the garden from the kitchen window more than I usually do. There is something in its persistence that I find useful. Gregory and I have been sleeping separately since February, though neither of us announced this. It simply happened, the way certain domestic arrangements happen, through the accumulated logic of small choices. He goes to bed later than I do, and in the first week after the conversation, he was simply still awake when I went upstairs, and when I woke in the morning, he was in the guest room, and then the next night the same, and then it was simply the arrangement. The master bedroom is mine. The guest room is his. We do not discuss this. What we discuss in those 3 weeks is mostly practical. The schedule for the house, who needs it when, since we both work from home on different days. Groceries, since we are still in the strange position of sharing a kitchen. Logistics that have the specific quality of logistics after love. Accurate, cooperative, faintly sad in the way that accuracy can be sad when it replaces something else. He is very careful with me during this time. This is something I notice, that he treats me in these 3 weeks with a consideration that is almost tender. The coffee prepared, the small domestic gestures maintained. There are moments when I catch him watching me in a way that I cannot fully categorize. Not guilt, exactly, but something in the vicinity of guilt, or perhaps something in the vicinity of grief. He is intelligent enough to know that what he has arranged is not honorable. He does it anyway, but he is not at ease with the dishonor, which is a small distinction and also a real one. I wonder, in those weeks, whether he would have done it differently if he had believed I was capable of finding out. I think he would. He is not someone who enjoys winning by cheating. He enjoys winning by being better, by being more prepared, by thinking further ahead. What he did with Sandra Hewitt and the asset transfers was not in the spirit of how he wants to see himself, but he wanted to protect what was his more than he wanted to be the version of himself who protected it correctly. This is not a defense of him. It is just the truth, which I try to keep specific. April 18, 1920. 3 more days. On the 19th, I move a portion of my savings account to a new account he has no knowledge of at a different bank. This is legal. This is protected. In New York, marital assets cannot be dissipated or hidden, but separate property can be managed freely, and this money is from my earnings, held in my name, and has been my own since before I made the decision to separate. I am not hiding it. I am protecting it. These are different things. On the 20th, a Sunday, Gregory and I walk to the farmer's market at Abingdon Square. It is something we have done on spring Sunday mornings for years, and I am performing this routine with the knowledge that it is almost certainly the last time I will do it with him. And this knowledge is strange, not because I grieve it, but because it is so intact. The market, the vendors, the bunch of tulips he buys for the kitchen table because I have always liked cut flowers in the kitchen, the particular way the light looks on Hudson Street in the mid-morning of an April Sunday, all of it exactly as I remember it, and me moving through it like someone walking through a photograph that has not yet been taken. He hands me the tulips. I say, "Thank you." He says, "Of course." We walk home. April 21, Monday, one day before the consultation. I review everything I plan to tell Katherine Chen. I review the names: Alder Point Holdings, Hamptons, Warren Alden, deferred compensation, nominee accounts. I review the dates: the February 12 email, the Hewitt referral checks over 14 months, the Kings County filing. I review the amounts: 340,000, 620,000, 5.4 million, 1,850,000. I am very prepared. The offices of Chen Feynman Associates occupy the 21st floor of a building on Park Avenue South, between 27th and 28th Streets. The building is not flashy. It is the kind of building that exists in the mid-range of Manhattan professional real estate, respectable without being ostentatious, with a lobby that has good marble and slightly dated light fixtures. The elevator is fast. These are the things I notice because I am noticing everything on April 22, taking in the details of a place I am in for the first time and the first time simultaneously. The reception area is calm. There are plants, real ones, which I appreciate because fake plants in a law office suggest a certain relationship to reality that I find inauspicious. The receptionist asks for my name, finds it in the system, and offers me water. I take the water. I sit in one of the chairs, which are navy and very slightly more comfortable than they look, and I wait. Katherine Chen comes to get me herself, which is unusual for a senior attorney, and I will come to understand over the following months that this is characteristic of her. She does the small professional gestures that most people at her level delegate, not out of insecurity, but out of a precise understanding of how first impressions function. She has been doing this long enough to know that the client who sees the senior attorney walk across a lobby is a client who immediately recalibrates their assessment of what they are paying for. She is 44, with a quality of attention that is immediately palpable, the kind of focused listening that makes you feel, in the first 30 seconds of a conversation, that you are the only thing in the room. She is Chinese American, medium height, with reading glasses on a chain around her neck, and a gray blazer over a white shirt that is pressed with the specificity of someone who has thought about it. She extends her hand. "Katherine Chen," she says. "Thank you for coming in." I shake her hand. "Mara Ellison," I say. We walk back to her office. Her office is tidy, oriented to the south, with a view that takes in the downtown Manhattan skyline at a distance. The towers of the financial district, visible on clear days, small and bright and permanent. The desk is large. There is a whiteboard on one wall with nothing written on it. The chairs across from her desk are good chairs, the kind designed for people who are going to be sitting in them for a long time. She sits. She opens a notepad. She says, "Tell me about your situation." I have rehearsed this. I tell her the essential structure. Married 12 years. Husband is a senior partner at Vance Kellerman. I've recently told him I want a separation. I tell her there are assets, real property, partnership income, retirement accounts, and she will say, and? She says, what else? I say, I believe there are assets that aren't on the surface. I can't prove this yet, but based on my knowledge of my husband's practice, and specifically his expertise in asset structuring, I think the marital estate is significantly larger than what he's prepared to disclose. She looks at me with the expression of someone who has heard this before, has heard it from clients who were right and from clients who were wrong, and is making in real time an assessment of which category I am in. She says, can you be more specific about what you mean by significantly larger? I say, I think there's an LLC in Delaware that holds a property we both used that was transferred there to separate it from the marital estate. I think there are deferred compensation amounts that are structured as future assets, but that should count as marital property. I think there are investment accounts held through a private banking relationship that don't appear on the tax returns. I pause. I say, I believe the actual marital estate is somewhere in the range of $5 to $6 million. I think he's prepared to disclose roughly half that. Katherine Chen writes something on her notepad. She says, what's the basis for your belief about the LLC? I say, he talked about Delaware LLC structures in relation to real property quite a bit. It was part of his practice, and there were periods in the last few years when he was dealing with something related to real estate that he was deliberately not specific about. I noticed. I wrote down dates. This is partially true. I did notice in the first life, not clearly enough to act on, but enough to register as a vague discomfort. What I don't tell her is that I know the LLC name and its registration date and the name of the property it holds and the name of the registered agent. I will let that come out through discovery. I don't want to explain how I know it. She says, and you haven't retained anyone else? I say, no, I came to you first. She writes again. Then she sets down her pen and she says, I'm going to need to run a conflict check. Given your husband's firm, there may be an issue. I say, I know. I was aware of that possibility. Is that going to be a problem? She says, let me run it and see. It can sometimes work both ways. If we have a prior relationship with the firm, we may be conflicted from representing them in the future, which means we can represent you. But we need to check carefully. Can you give me his name and the firm name again? I give her Gregory's full name and the full name of Vance and Kellerman LLP. She writes these down. She says, it typically takes us 24 to 48 hours to complete a conflict check. If we're clear, I can move forward with the engagement. If we're conflicted, I'll tell you immediately. I say, thank you. She says, I want to be direct with you about something. If what you're describing is accurate, the hidden LLC, the deferred comp, the private banking accounts, this is a case that's going to require forensic accounting. We have an accounting partnership we use regularly for exactly this kind of work. Their fees are separate from ours, but we coordinate closely. The total cost of this case, if it goes to litigation, could be significant. I say, I understand. She says, what's your financial position right now? Can you fund a full case independently? I say, I have my salary. I'm VP of Marketing at MedAccess 212 plus bonus. I have savings that are separate, that are mine. I can fund the initial phase. I may need interim support from the estate eventually, but I can start. She nods. She looks at me for a moment, the look of someone making a final assessment, and says, okay, I'll run the conflict check today. Someone will call you tomorrow or Wednesday. I stand. I shake her hand. I walk to the elevator. In the elevator, I am briefly, carefully, very still. The call comes the next morning at 9:47 a.m. It is Marcus Trello, the intake coordinator. He says, I'm calling to let you know that we've completed the conflict check. We do have a prior consulting relationship with Vance and Kellerman that's in our system, which means we're not able to represent the firm or its partners in any matter that's substantially related to that consultation. However, he pauses. I hear a page turning. The conflict runs in the other direction. We're clear to represent you in this proceeding. In fact, representing you is specifically permissible because you are an adverse party to someone connected to the conflicted firm. The conflict locks us out from them. It doesn't lock us out from you. I say, I understand. He says, Miss Chen would like to schedule the next meeting at your earliest convenience to go over the engagement agreement and begin gathering information. She's available Thursday morning at 9 a.m. or Monday afternoon at 2. I say Thursday at 9. He says, perfect. We'll email you the engagement agreement to review beforehand. The initial retainer is $4,500. I say, that's fine. He says, and Miss Ellison. Miss Chen asked me to let you know that once you've signed the retainer, we will formally notify opposing counsel that we represent you. If your husband's firm was considering any alternative arrangements regarding counsel, our representation will be on record. I say, I understand. What he means is, once I sign the retainer, Chen Feynman Associates is on record as my attorney, and any move Gregory's team makes toward retaining Katherine Chen themselves will be blocked by the existing conflict entry. What I already know is that this isn't a risk Gregory has thought about. He didn't think about it in the first life, when there was no reason to, and he hasn't thought about it in this life yet, because he still believes I am going to call Sandra Hewitt. I hang up the phone. I close my office door. I allow myself for exactly 30 seconds the satisfaction of a thing done correctly. Then I open my laptop and I go back to work. Thursday, April 24. I go to Chen Feynman at 9 a.m. I have read the engagement agreement twice. The retainer is $4,500. Katherine Chen explains the structure of the proceeding, her approach to asset identification, the role of the forensic accountant. I listen. I sign. I write the check. When I hand it to her, she sets it on the desk and says, "Tell me everything you know about his financial life. Not what you can prove. Everything you know." I tell her. I tell her about the Hamptons house. I tell her about the periods when Gregory was vague about real estate conversations. I tell her about the private banking relationship I had seen references to on documents I'd glimpsed over the years, a bank I didn't recognize, account statements that came in envelopes with the bank's name, that Gregory redirected quickly. I tell her about the deferred compensation conversation I'd overheard, not the specific numbers, but the structure, the mention of unvested equity, in a context that suggested it was significant. I tell her about Warren Alden, Gregory's close colleague, the one he seemed to be in close communication with on financial matters. She writes all of this down. She asks specific clarifying questions. She does not look at me the way some attorneys look at clients who claim there are hidden assets, with a barely concealed skepticism, a professional adjustment of enthusiasm downward. She looks at me the way someone who has found many hidden assets in her career looks at someone who is describing the texture of concealment accurately. She says this is a good starting point. We're going to subpoena the partnership agreements first. That's usually where the deferred comp structure lives. Then we'll run Delaware LLC searches on his name and any associated names you can give me. I give her Warren Alden's name. She writes it down. She says, "How confident are you that there's a Delaware LLC connected to an East Hampton property?" I say, "Quite confident." She says, "Do you have any sense of when it was formed?" I say, "I think a few years ago, before this came to a head, maybe 4 years ago." She says, "That's helpful. We'll search the formation date range." I say, "And I want to ask you something about opposing counsel." She says, "What about them?" I say, "I know Gregory will be represented by attorneys at Vance and Kellerman's family law division. They're very good. I want to understand, given that you had a prior relationship with the firm, is that going to complicate our interaction with them?" She says, "Actually, it tends to work in our favor. They know us. They know how we work. They're not going to try the procedural moves that less sophisticated opposing counsel sometimes tries, because they know we'll catch them. And they know that if they've missed something, we're going to find it." I say, "Good." She says, "One more thing. Do you have any reason to believe your husband has specifically taken steps to affect the proceeding? Not hiding assets, that's what we're investigating, but any interference with how the proceeding itself moves forward." I look at her. I think about this carefully. I say, "I have reason to believe he may have been thinking about this situation before I formally raised it with him. I don't have proof, but I think his approach to this has been strategic from the beginning." She nods. She says, "If that's the case, we may eventually want to look at his firm's internal communications in the relevant period. Not standard in a divorce proceeding, but if we can establish that the litigation strategy was being managed from inside the adverse firm, it becomes relevant." I say, "I understand." I sign the retainer. I walk out. In the elevator on the way down, I check my phone. April 24, 26 days before the original filing date. Katherine Chen is my attorney of record. The conflict is locked. Gregory does not know yet. He is going to find out very soon. Thursday, April 24. The retainer is paid. The engagement is active. When I leave Chen Feynman's offices, I stop for coffee at a place on 27th Street, a nondescript counter service spot, the kind that exists purely to provide coffee to people who work in the buildings around it, with no pretension and no aesthetic agenda. I order a black coffee. I stand at the counter for 5 minutes. The coffee is good in the specific way of coffee that is exactly what it says it is. I think about Sandra Hewitt in her office on West 72nd Street. I think about her answering phone. I think about the call that will never come, from me to her, asking about representation, beginning the process that destroyed the first life. The call that, in this life, I will never make because I have already made a different call. The process that destroyed the first life is not going to happen because Katherine Chen signed my retainer this morning, and the conflict entry is now locked in her firm's database. I drink the coffee. I think about 42 days and how I used them. I think about the second life, 9 months old, and the moment on the day I woke up in it when I stood at the window of the West Village townhouse and looked at the street and thought, 42 days. The coffee is gone. I go back to work. April 25, Friday. Chen Feynman Associates files the notice of appearance in New York County Family Court. My name, Gregory's name, Katherine Chen's name, the filing date. On record, at 11:43 a.m., I receive a text from Gregory that reads, I just got a call from the firm's family law partners. They said they received a notice of appearance for your case. Are you going to tell me what's going on? I text back, I retained an attorney. I told you I was going to. He calls. I let it go to voicemail. He does not leave one. That evening at dinner, he is quieter than usual. He has the quality of someone who has been recalibrating. He has run by now the mental calculus. Who is Katherine Chen? What does she do? What does it mean that she filed in New York County? What does the conflict entry in their system mean for his team's ability to retain her? And what does it mean that I got to her first? He is quiet for a long time. Then he says, I looked her up. Katherine Chen. I say, I assumed you would. He says, she does forensic work. I say, yes. He says, Mara, I want this to be straightforward. I don't want it to be complicated. I say, I think we just have different ideas about what straightforward means. He says nothing. He refills his water glass. He eats the rest of his dinner. That night, I lie in the guest room. I have been sleeping in the guest room since the February Sunday, which was not a decision either of us explicitly made, but which had simply organized itself, the way endings sometimes do. And I look at the ceiling and I feel, for the first time since waking up in this life, something that is almost rest. Not because the work is done. The work is far from done. But because the thing that ruined the first life has been undone. The thing that needed to happen first has happened. Katherine Chen is my attorney. The conflict is locked. Sandra Hewitt will never touch this case. Everything that follows will be hard. But it will be mine. What follows from April 28 through the summer is the particular kind of work that does not look like work from the outside, but is the densest kind of labor. The work of documentation, of subpoenas, of waiting for documents to arrive, and then reading them slowly, carefully, finding what is there, and mapping the shape of what is not. Katherine Chen moves the case with a precision I have never experienced in a legal proceeding, partly because I have never in any life had this kind of legal representation, and partly because Katherine Chen is simply very good at what she does. She is not dramatic about it. She does not narrate her strategy out loud or reassure me with language designed to sound confident. She narrates facts. When a document arrives, she tells me what it says. When a gap appears in the record, she tells me what she is going to do to fill it. This is the only kind of attorney I trust, and I am deeply grateful, in a way I keep very much to myself, that she is the one doing this. The first subpoena is to Vance and Kellerman for the full partnership agreement and all amendments, Gregory's capital account statements, and the firm's records of deferred compensation arrangements for all partners in Gregory's tier. This subpoena is filed on May 2. Vance and Kellerman's counsel, David Price, a senior family law partner who represents Gregory personally, which is itself a detail Katherine Chen will note, objects on grounds of relevance and firm confidentiality. Katherine Chen's response brief, filed May 9, is 22 pages. I read it. It is very good. The central argument is that a spouse's ownership interest in a professional partnership is a marital asset, and that the complete valuation of that interest requires access to the partnership agreement, the capital accounts, and any deferred compensation arrangement, all of which are standard discovery items in high net worth divorce proceedings involving partnership income. The firm's confidentiality interest, the brief argues, can be accommodated through protective order, but does not create a basis for wholesale withholding. The family court judge, Judge Loretta Finelli, a woman in her late 50s with a reputation for impatience with procedural gamesmanship, rules in our favor on May 14 with one modification. Certain client identifying information may be redacted. The partnership agreements, capital accounts, and deferred compensation records must be produced within 30 days. They arrive on June 10. Katherine Chen's forensic accounting partner, a woman named Dr. Rita Vasquez from the firm Vasquez and Connolly, begins reviewing them the same day. The second subpoena is the Delaware Corporate Records Search, which is a different kind of thing. Not a formal subpoena to a party, but a records search through the Delaware Division of Corporations. Katherine Chen files this request on May 7, asking for the names and formation dates of all Delaware LLCs in which Gregory Vance or Warren Alden is listed as manager, registered agent, or authorized member. The search returns 3 results. 2 of them are entities I have no knowledge of. One is a personal investment vehicle Gregory formed in 2015, which is a legitimate single-member LLC holding index funds, and which turns out to be a marital asset that was not initially disclosed. The second is a holding company connected to a real estate investment group that Warren Alden is involved in, which has no direct connection to Gregory. The third is Alder Point Holdings LLC. Alder Point Holdings LLC was formed in Delaware on March 4, 2021. The registered agent is Warren Alden. Gregory Vance is listed as the sole manager. The company's stated business purpose in the formation documents is investment and management of real property. It has a registered address in Delaware and a New York contact address, the Vance and Kellerman offices. Katherine Chen calls me the day this search result comes back. She says, "We found it." I say, "Tell me." She says, "Alder Point Holdings LLC. Formed in 2021. Delaware. Manager is your husband. Registered agent is Warren Alden. No other members listed. We're going to subpoena the company's records and the bank accounts associated with it." I say, "The East Hampton property. There will be a deed transfer from his personal ownership to the LLC, probably filed in Suffolk County within 6 months of the LLC formation." She pauses. She says, "You know a lot about this for someone who didn't know there was an LLC." I say, "I've been thinking about what I know and what I don't know, and I know what kinds of structures he uses." She says, "Okay, we'll pull the Suffolk County deed records, and we're going to subpoena the LLC's bank accounts through the operating bank, which we'll identify from the formation documents. If they moved an East Hampton property into this structure, there should be a transfer document, probably a warranty deed, on file with the county. The Suffolk County deed search finds the transfer. It was recorded on August 19, 2021, 5 months after the LLC was formed. Gregory Vance transferred the property at 14 Windmill Lane, East Hampton, New York, to Alder Point Holdings LLC for the stated consideration of $1, the standard consideration used in non-arm's length transfers to make them technically valid while avoiding transfer tax. The property's assessed value at the time of transfer was $1,300,000. Its market value, which an independent appraiser we subsequently retain will establish, is $2,140,000. This property was transferred in 2021. We did not separate until February of this year. The transfer was, in legal terms, a dissipation of a marital asset, a restructuring of an asset that was part of the marital estate into a vehicle designed to place it outside the marital estate, done in anticipation of a dissolution that had not yet been announced. Katherine Chen says this is very good. The premarital conversion issue, the timing of the transfer relative to the marriage, is going to be central. We need the full documentation of when he decided to do this. I say, "What do you mean?" She says, "We need to know if this transfer was done in contemplation of divorce. If he transferred the property to the LLC specifically because he was already thinking about the marriage ending, that affects the analysis significantly. It moves the issue from restructuring his assets to fraudulent transfer in anticipation of divorce." I say, "How would you establish that?" She says, "Internal communications from around the time of the transfer. Emails between him and Warren Alden, or between him and the firm's real estate counsel, discussing the purpose of the LLC. We'll subpoena those." And this is where things begin to accelerate. The subpoena for internal Vance and Kellerman communications in the period March 2021 through August 2021, relating to the formation and operation of Alder Point Holdings LLC, is filed on June 17. David Price objects. The objection cites attorney-client privilege, work product protection, and the firm's First Amendment right to keep client communications private. Katherine Chen's response brief is 31 pages. I read every page. Her central argument: the privilege does not protect communications in furtherance of fraud. The fraudulent transfer doctrine in New York, the UFTA, the Uniform Fraudulent Transfer Act, now the New York debtor and creditor law, makes a transfer fraudulent if it was made with actual intent to defraud a creditor. A spouse in the context of anticipated dissolution is a creditor for UFTA purposes. If the LLC formation and property transfer were made with the intent of defrauding me of my interest in the marital estate, then communications related to those transactions are not privileged. The court schedules a hearing for July 8. I attend. Judge Finelli is, as advertised, impatient with gamesmanship. David Price argues privilege with the controlled vehemence of a man who knows the documents he's protecting are very damaging. Katherine Chen argues the fraud exception with the quiet precision of someone who has made this argument before and won. Judge Finelli takes it under advisement. She rules on July 15 the communications must be produced for in-camera review. She will examine them herself and determine what is and is not privileged. Production to chambers within 10 days. David Price calls Katherine Chen the same afternoon. I am told about this call the next morning. He says, according to Katherine Chen's characterization, he wants to discuss settlement framework. Katherine Chen says she told him, "We're in the middle of production. Let's complete discovery and then talk about settlement." He says my client is open to a preliminary discussion. She says my client's position is that we complete discovery first. She tells me this and she says, they're worried about what's in those communications. I say, I know. She says, you seem very confident about a lot of things in this case. I say, I have good instincts. She gives me a look that suggests she is not entirely convinced this is only instincts, but she does not press the point. This is another thing I appreciate about Katherine Chen. She does not need to understand everything in order to do her job. I need to tell you about Dr. Vasquez because her work is the center of the whole thing, and I have not yet described the quality of it, which deserves description. Rita Vasquez has been doing forensic accounting in family law cases for 19 years. She comes recommended by Katherine Chen as someone who has testified in over 100 contested proceedings, who has never had a finding successfully challenged on appeal, and who has a specific specialty in private banking concealment, which is exactly the variety of concealment we are dealing with. She is compact and precise, and she speaks in a way that consistently suggests she has done more work than she is showing you, which is the forensic accountant's version of composure. She meets with me twice in June. The first meeting is an intake. She asks me to describe everything I know or remember about Gregory's financial life in as much detail as I can. She takes notes on a yellow legal pad in a handwriting so small I can barely see what she's writing. She asks follow-up questions about timing, about specific institutions, about the character of certain documents I remember seeing without understanding. I tell her what I can tell her, which is carefully calibrated to be informative, without being implausibly specific. I am walking a line in all of these conversations between using what I know and being unable to explain how I know it, and Dr. Vasquez, like Katherine Chen before her, does not press me for explanations. She receives information and uses it. The second meeting, in late June, is a review of the partnership agreement documents that have arrived from Vance and Kellerman. She has been through them 3 times. She spreads them on the conference table and walks me through what she has found with the efficiency of someone who has done this many times and is comfortable with the part that requires translating technical financial structure into plain language. The deferred compensation, she explains, is structured as a carried interest arrangement, a type of compensation common in professional service firms that ties payment to future performance rather than current earnings, specifically designed to make the asset feel future-oriented when it is, in fact, an accruing present value with a significant marital component. She shows me the specific provision in the partnership agreement, the section numbers, the language. She says, if opposing counsel tries to argue this is non-marital, they're wrong and I can explain precisely why to a judge in 15 minutes. I say, I believe you. She says, the nominee accounts are going to take longer. We're following the transfer trail from his disclosed accounts outward. The Wyoming entities are registered to nominee members, people paid to serve as official members without real ownership, which is a common structure when the real owner wants to appear absent from the record. We have to trace through the bank transfers to establish beneficial ownership. That takes time and sometimes requires subpoenas to the correspondent banks. I say, how long? She says 4 to 6 weeks if we get cooperation, possibly longer if there are objections. There are objections. There are always objections. Katherine Chen handles the objections. The correspondent bank subpoenas take 8 weeks in total, but the trail when it resolves is clear. Dr. Rita Vasquez's forensic accounting report, completed on July 22, covers 3 areas: the partnership interest valuation, the deferred compensation analysis, and the nominee investment accounts. The partnership interest valuation is the most straightforward. Gregory's capital account at Vance and Kellerman has a current balance of approximately $600,000. His current equity share in the partnership, valued according to standard professional practice firm valuation methodologies, is approximately $1,200,000. These are real, disclosed numbers. They came from the partnership agreements. But they are numbers that were not in the original discovery in the first life, because Sandra Hewitt never subpoenaed them. The deferred compensation analysis reveals $342,000 in unvested equity that vests over the following 3 years. Under New York law, unvested deferred compensation earned during the marriage is a marital asset, valued by proration. Dr. Vasquez calculates the marital portion at $288,000. The nominee investment accounts require the most work. These are accounts held in the names of two entities, both single-purpose LLCs, both registered in Wyoming, where LLC member information is not public, that Dr. Vasquez identifies through a combination of the Alder Point Holdings bank records and a pattern of transfers in Gregory's disclosed personal accounts. The transfers show regular movement to entities that don't appear on any disclosed financial statement. Dr. Vasquez traces these through the banking records to the Wyoming LLCs, and from the Wyoming LLCs to an account at a private bank, First Meridian Wealth Management, which I have seen referenced on documents Gregory moved quickly, holding, in aggregate, $617,000. $617,000 that Gregory did not disclose. The total marital estate, as Dr. Vasquez calculates it in her final report, $5,412,000. I received the report on July 23. I read it in my office with the door closed. Then I go to the window and I look at Third Avenue, which is doing what Third Avenue always does at midday, and I breathe. 5.4 million. He was going to settle me at 32% of a disclosed estate, less than half that size. Dr. Vasquez's report goes to David Price's office via Katherine Chen on July 25. On July 26, David Price calls again about settlement. What I notice over the summer and into the fall is the way Gregory changes. He is not, in the ordinary sense, a man who panics. He is a man who responds to threat by becoming more controlled, more measured, more deliberate, which is a kind of intelligence, and it is also, in the context of this proceedings, something I can read precisely because I have known him for 15 years and because I know what he knows he's done. In the first weeks after Chen Feynman's notice of appearance, he is watchful. We are still in the house together. We will remain in the house until the September order establishing interim support and temporary occupancy, which gives me the house for the duration of the proceeding. And in those months, I am living with a man who is receiving bad news from his attorneys on a regular basis and managing his response to that news in the presence of someone he is trying not to betray the management to. He does not betray it. He is very controlled. But I know him, and I can read the quality of his silence in a way that tells me something about what has arrived that day. When the Suffolk County deed records came back, the silence had a particular texture, tighter, with a quality of calculation. When Dr. Vasquez's report was delivered, he did not come home for dinner. He texted that he was staying late at the office. I had the kitchen to myself, and I made pasta, and I ate it in the particular quiet of a house that is almost someone's past. When David Price called Katherine Chen about settlement, I was not surprised. What surprised me was the number in the first preliminary offer. The first preliminary offer, communicated through David Price on July 28, was 42% of the disclosed marital estate. The estate as Gregory's team defined it, which still excluded Alder Point Holdings and the nominee accounts. At their number, 42% was approximately $900,000. Katherine Chen communicated our position. We are negotiating based on the full marital estate as identified in Dr. Vasquez's report. We are not negotiating based on a partial disclosure. When they are ready to respond to the full report, we can continue the conversation. David Price said, my client disputes the Vasquez analysis on several points. Katherine Chen said, we anticipated that. We're prepared for litigation if necessary. The dispute, when it arrived formally in Gregory's response to the forensic report, took three specific forms. First, they argued that Alder Point Holdings was a legitimate business entity formed for legitimate business purposes, specifically estate planning and asset management, and that the East Hampton property was Gregory's premarital property acquired before our marriage, and therefore not a marital asset. This was a half-truth. He had acquired the East Hampton house 2 years before we married, but he had also spent 8 years of the marriage, during which we both used and maintained it, in a way that created what New York law calls transmutation, treating the property as a marital asset in practice, even if it was technically separate property at the time of acquisition. Katherine Chen's brief on this point is thorough and cites 6 relevant cases. Second, they argued that the Wyoming LLC accounts were not attributable to Gregory personally, that they were third-party investment vehicles he had a limited interest in, and that the funds in them were not marital property. This argument required Dr. Vasquez to trace the transfer chains more completely, which she did over the following 3 weeks, producing documentation showing that Gregory was the beneficial owner of both Wyoming entities, that he controlled the accounts, and that the regular transfers from his disclosed personal accounts to these entities were the source of the funds in them. Third, they argued about the deferred compensation valuation methodology, a technical argument about proration that had some basis in legitimate professional disagreement, but that Dr. Vasquez addressed fully in her supplemental report. None of these arguments were frivolous. They were the arguments of competent attorneys protecting a client who had done things that were hard to defend. Katherine Chen expected every one of them and had responses ready for every one. What shifted the dynamic in mid-August was the in-camera review. Judge Finelli completed her review of the Vance and Kellerman communications on August 12. She issued her ruling on August 15. The communications were not privileged. The privilege exception for fraud applied. The emails were ordered produced to both parties within 5 days. The emails arrived on August 20. I don't read them immediately. Katherine Chen schedules a meeting for August 22, a Thursday, and I go to her office that morning, and she has the document production on the table between us, and she says, "I want to go through the most significant of these with you. Some of them are difficult." I say, "Okay." She opens to a page. She says this is from Gregory's email account, sent to Warren Alden on March 3, 2021. The subject line is a structure update. The body says Rita confirmed the Delaware filing. I is active as of today. Transfer timeline, August after the fiscal year. Per our discussion, the rationale if asked is estate planning. The HH recommendation should wait until we have a clearer picture of timing. I don't want to move too soon. She looks at me. She says I is Alder Point Holdings. We believe, Sandra Hewitt. The room is very quiet. I have known this email existed because I know the broad structure of what happened, but hearing it read aloud, the specific language, the casualness of it, the HH recommendation should wait until we have a clearer picture of timing, is something different than knowing. It is a confirmation that carries weight, that knowing alone does not. He was planning this. March 2021, 8 months before we separated in February of this year. He was planning it. I say, there's another email. February 12 of this year. To Warren Alden. The subject line is preliminary assessment of exposure. She looks at the stack. She finds it. She says, "You know about this one?" I say, "I assumed it existed." She reads it. She is quiet for a moment. Then she says, the third paragraph says, and I quote, "She's still emotional from the conversation. I don't expect her to retain sophisticated counsel. If we move quickly on the HH recommendation, we control the process." She puts the email down. She says, "This is very significant. In a straightforward evidentiary sense, this email establishes that he knew about your separation 2 days after you told him. He identified a specific vulnerability, your counsel selection, and he took steps to exploit it. That's relevant to the fraudulent transfer analysis and to sanctions." I say, "Sanctions?" She says, "Attorney sanctions. New York court rules allow sanctions against a party who engages in litigation conduct undertaken in bad faith or for the purpose of deceiving the court or the opposing party. If we can show that Gregory orchestrated the retention of conflicted counsel to prejudice your discovery position, which this email suggests he did, even though you didn't end up using that counsel, we can ask the court to sanction his legal fees." I say, "He recommended an attorney to me. I didn't use her." She says, "He recommended an attorney with a financial relationship with his firm. The intent was to prejudice your legal representation. The fact that you went elsewhere doesn't eliminate the intent. It limits the damage, but the intent is documented." I let this sit for a moment. Then I say, "What does the sanctions request look like?" She says, "We file a motion for sanctions under Rule 130 of the Uniform Civil Rules. We document the referral relationship between Hewitt and Vance and Kellerman, which we'll need to subpoena their accounts payable records to establish, and we argue that Gregory's recommendation of Hewitt constituted an attempt to compromise your legal representation for his benefit. The sanction is typically fees. He pays a portion of your legal costs." I say, "Let's do it." She says, "It's going to make this more combative." I say, "It already is combative. He just hasn't acknowledged it yet." She nods. She starts writing. The sanctions motion is filed on September 4. To file it, we subpoena the Vance and Kellerman accounts payable records for all payments to Sandra Hewitt in the period January 2022 through February of this year. The subpoena also covers the referral tracking system, if any. David Price objects. The objection is the most aggressive I've seen in the proceeding. He characterizes the subpoena as a fishing expedition. as an attempt to embarrass the firm, as a violation of third-party privacy rights. The motion is heard on September 19. Judge Finelli takes it under advisement, as she does with everything, and rules 2 weeks later. The accounts payable subpoena is granted in full. The referral tracking records are granted with a protective order limiting their use to this proceeding. The records arrive on October 4. 14 payments. $241,800. Sandra Hewitt's firm name appearing in the Vance and Kellerman vendor records as Hewitt Legal Services, cross-referral arrangement. Cross-referral arrangement. They were paying her under a cross-referral framework that was facially legitimate. She was sending clients to a firm they had a relationship with, but the timing, the amounts, and the complete absence of any disclosure to me, her client, made it what it was. Katherine Chen files the sanctions motion with the new documentation on October 10. At the same time, I place a call to the Attorney Grievance Committee, 1st Judicial Department. I speak with the intake officer for approximately 20 minutes. I describe what I know. They request documentation, which I provide through Chen Feynman. A file is opened. 2 things are now on record that did not exist in the first life. September also brings the temporary occupancy order. Judge Finelli grants it on September 18. I have the right to remain in the Charles Street townhouse during the pendency of the proceedings. Gregory must vacate within 30 days. He is also ordered to pay interim spousal support of $7,500 a month, not because he has been ordered to permanently, but because the interim order maintains the economic status quo while the case progresses. He moves to an apartment in Tribeca. I know the building. It is the kind of building that says a very specific thing about who you are when you choose it, expensive in a way that is entirely about the building's name rather than its qualities. He moves in on October 3. I am alone in the Charles Street townhouse for the first time since February. On the first evening, I make dinner and eat it at the kitchen table, and I do not think about anything in particular. The kitchen smells of whatever I've been cooking, and the faint cedar of the house, and the particular fall air that comes in through the small window above the sink when I have it open. It is quiet in the way a house is quiet when it is your house and not also someone else's. I am not celebrating. I am not sad. I am in the house and it is mine, and the case has months still to go. There is a thing I want to tell you about the period between the forensic report and the deposition, which is, I continue to live. This sounds obvious. It is not obvious when you are in the middle of a complex contested legal proceeding that is also the dismantling of a 12-year life, to continue living the ordinary texture of your days. The proceeding becomes, if you let it, the primary weather of all your waking hours, the thing you are in, the thing happening to you, the organizing fact around which everything else is arranged. I have done this before in the first life, and it made me smaller. I spent 15 years in the Jersey City apartment, being someone to whom the settlement had happened, rather than someone who had survived it and moved forward. I decide in the second life not to let the proceeding be everything. I work at MedAxis. In August and September, I lead the rollout of a new product line, a monitoring device for cardiac patients that has been in development for 2 years, and whose marketing strategy I have been building since I inherited the project in January. The rollout is good. The launch metrics are strong. Jamie Ortega runs the Eastern regional campaigns with the kind of initiative that tells me he is ready for more responsibility, and I bring this up in his September review, and he receives it with the gratified composure of someone who already knew it but needed to hear it officially. I see Cora. I see her for lunch in late July and early September and October. The conversations meander in the way that long friendships allow, neither of us needing to establish context, both of us free to start from wherever we are. She knows the broad outlines of the proceeding. She does not ask for specifics I don't volunteer. She does ask in October over coffee at her office, "Are you sleeping?" I say, reasonably. She says, "That means no." I say, "That means adequately." She says, "What is the quality of the adequacy?" I say, "It's the kind of sleeping that is interrupted by thinking rather than by fear," which feels like progress. She says that sounds like a distinction only someone who hasn't slept well in months would make. I say, "You're not wrong. The truth is that I sleep in fragments. Not with anxiety. The cold certainty doesn't leave room for anxiety in the conventional sense, but with the quality of a mind that is running processes during hours that would otherwise be rest. I wake at 3 a.m. sometimes, and lie in the dark of the master bedroom, and think about the documents in the timeline, and the things Katherine Chen has said, and the things I know that the documents will eventually confirm. The 3 a.m. thinking is not unpleasant. It is a form of preparation. I also think at 3 a.m. about the 12 years. Not obsessively, not with the grinding quality of something unresolved, but with the specific and sometimes surprising revisitation of real memories. The restaurant on Bleecker, the car driving through Queens, the farmer's market on Abingdon Square in every spring we had, Gregory's hands on the newspaper on the February Sunday, the tulips. I let myself think about these things. I do not arrange them into a narrative that makes the betrayal easier to understand or the marriage easier to dismiss. I let them be what they are, a mixed record of a real thing that happened and then became something else. In September, I walked through the garden for the last time before the temporary occupancy order. The perennials have come and gone, the spring bulbs, the early summer things. And now in September, there are the late season flowers, the dahlias and the black-eyed Susans, going russet and deep in the turn of the light. I stand in the garden for a few minutes, and I look at what grew this year without being attended to very carefully, because we were too much in our respective proceeding-related thoughts to give the garden the attention it needed, and it grew anyway, which is the garden's particular position, indifferent to our internal lives, doing what it does in the time it has. I go back inside. I start packing the things that are mine. On November 4, I go to the offices of Vance and Kellerman to be deposed. The Vance and Kellerman offices are in a tower in Midtown, 46th floor, with the kind of reception area that exists primarily to communicate how long the firm has been doing this and how seriously they take themselves. The marble is very good. The view is the Manhattan skyline at maximum visibility. The waiting area has 2 chairs and a glass table with a single orchid, which is real and perfectly maintained. And I think about the orchid for a moment before a paralegal leads me back to the conference room where the deposition will be conducted. The conference room has the Hudson visible in the distance, to the west, through a long window. The table is large and dark. David Price is there, and a second attorney from the family law group, and the court reporter, and a video operator, and Katherine Chen, who is sitting next to the chair they've prepared for me, and who looks in this room, in this firm, at these people, the way someone looks when they know exactly where they are and exactly what they're doing. I sit down. The deposition lasts 4 hours and 17 minutes. Warren Alden is there for the first 20 minutes, not being deposed, simply present, sitting at the far end of the table with a yellow legal pad, not writing anything, watching. This is, I know from Katherine Chen's briefing, a psychological tactic. He is there to signal that the firm is taking this proceeding seriously. He is also there, I believe, to watch me, to assess whether I am the version of Mara Ellison he and Gregory planned around, the one they thought would be emotional, the one they thought wouldn't retain sophisticated counsel. He leaves after 20 minutes. I don't know what he concludes from those 20 minutes, but I know what he doesn't see, the cold certainty which lives below any surface he can read. David Price is thorough and professional and excellent at his job. He asks about every aspect of my financial life, my knowledge of Gregory's finances, my earnings history, my separate property, my understanding of the marital estate. He asks these questions with the specific patience of someone who is looking for something, an inconsistency, a claim that overreaches, a place where I say something I don't actually know and can be shown not to know. He does not find what he's looking for. I know exactly what I know and exactly what I don't know, and I do not confuse the two. This is, Katherine Chen will tell me afterward, genuinely unusual. Most clients, she says, reach for more than they can substantiate under deposition. It is the opposite of my problem. My problem is that I consistently know things with a precision that is difficult to explain without the explanation sounding strange. In the early afternoon section, Price shifts to the Alder Point Holdings question. He asks me about my knowledge of the East Hampton property. I describe what I knew, that it existed, that we had visited it, that I understood it to be an asset Gregory had brought into the marriage. He asks if I knew about the LLC. I say no. He asks when I first heard the name Alder Point Holdings. I say when Chen Feynman's Delaware search returned it. He asks, and prior to that, you had no knowledge that the property had been transferred to a corporate entity? I say, no. He asks, did you have any reason to believe your husband had taken steps to restructure his assets in anticipation of divorce proceedings? I say I had general concerns about asset complexity. That's why I retained an attorney with forensic experience. He asks, but no specific knowledge. I say no specific knowledge prior to discovery. This is accurate. What I have in my head is not knowledge in any juridical sense. It is memory from a life that doesn't exist in any court record. He moves to the nominee accounts. He asks about First Meridian Wealth Management. I say I had seen the name on documents without understanding its significance. He asks how I came to provide that name to my attorney. I say that in reviewing my memory of Gregory's financial life, I remembered seeing documents from that institution, and I provided the name to Dr. Vasquez as a starting point. He asks, what documents? I say correspondence that came to the house, account statements, or similar. I saw the institution's name and the documents were moved quickly. He asks, can you produce those documents? I say, I cannot. I don't have them. I provided the name from memory. He writes something. This is the moment I am most careful about. I cannot explain the level of detail I have provided to Chen Feynman's investigation without appearing to have had access to information I couldn't have had. I have, throughout this proceeding, navigated this by providing directional information, pointing toward where things are, rather than stating precisely what they contain, and allowing the forensic team to do the work of finding and quantifying them. The story I am telling, under deposition, is the story of a woman who was paying attention, who knew her husband's world well enough to know where to look, and who hired an attorney capable of looking carefully. This story is true. It is incomplete. There is a second skeleton inside it that I cannot explain, but nothing I have said under oath is false. He asks in the late afternoon section about Sandra Hewitt. He asks, did you speak with Sandra Hewitt at any point? I say no. He asks, did you consider retaining her? I say, my husband mentioned her name. I did not pursue it. He asks, why not? I say I had already decided on a different approach. He asks, what approach? I say, forensic experience. As I mentioned, he asks, did you have any reason to distrust Miss Hewitt specifically? I think about this. I say, no specific reason. I made a judgment about the approach I wanted and pursued it. He asks, did you know at the time your husband recommended her that she had any relationship with his firm? I say, no. I learned about that through discovery in these proceedings. He asks, and is it your position that your husband's recommendation of her was improper? Katherine Chen objects, calls for a legal conclusion. Price withdraws the question. But the question has been asked, and the record has it, and the accounts payable documents are already in evidence. The second deposition of Gregory happens on November 11th. I am not present in the room for his deposition. Katherine Chen takes it. She tells me about it afterward with the specific economy of a person reporting data. He asserted the Fifth Amendment on two questions. One was a question about communications with Warren Alden in the period January through August 2021 regarding Alder Point Holdings. One was a question about his knowledge of the Sandra Hewitt referral relationship at the time he recommended her to me. Asserting the fifth in a civil proceeding is not the same as asserting it in a criminal one. In a civil case, the court can draw an adverse inference from a Fifth Amendment assertion, can assume, for the purposes of the proceeding, that the truthful answer would have been unfavorable to the party asserting it. Katherine Chen says, the fifth on the Hewitt question is particularly useful for us. It's an implicit acknowledgement that the honest answer, yes, I knew she was receiving referral fees from my firm when I recommended her to you, would be damaging. I say, and the age question? She says, same thing. He knew the Alder Point Holdings formation was designed to move the East Hampton property out of the marital estate before the divorce was formalized. He can't say that under oath. So he said nothing. I say, what does that do for us? She says, it strengthens the sanctions motion significantly. The adverse inference instruction on the Hewitt question, combined with the documentary evidence of the referral payments, gives the court a very clear picture of what happened. And the adverse inference on the H question supports our position that the LLC transfer was made in contemplation of divorce, which is relevant to the fraudulent transfer claim. I say, where are we on the overall settlement position? She says, they came back with another number after the deposition. 48% of the full estate, Dr. Vasquez's number. That's about 2.6 million. I say, what's your recommendation? She is quiet for a moment. Then she says, my recommendation is that you counter at 54% plus 5-year alimony at 10,000 a month, plus sanctions of 290 in attorney's fees. And I think we get it, or close to it. I say, why 290 specifically? She says, that's our total legal cost to date for this proceeding. The sanctions motion, if we win it, entitles us to reimbursement of fees incurred as a result of the sanctionable conduct. And we think we win the motion. I say, let's counter. She writes it down. She says, I want to manage your expectations about timeline. This will go back and forth for another month, probably. And he may push for mediation, which is his right. I say, if he wants mediation, I'll go. But not with the same parameters. She looks at me. She says, mediation with Katherine Chen on one side and David Price on the other is not going to go the way he's hoping. I say, I know. There is a thing that happens in mediation that I want to describe. because it relates to something Gregory's email said, and because I find it instructive about the nature of what he planned and what he did not account for. The email to Warren Alden, dated February 12, contained the line, "She'll be emotional in mediation." Use that. In the first life, I was emotional in mediation. I had spent months in a proceeding I did not understand, managed by an attorney who was not working for me, being presented with a financial picture that I sensed was wrong but could not articulate why. When David Price, who I now understand was representing Gregory directly even in those proceedings, put the settlement number on the table, I was tired and frightened, and the number felt both insufficient and inevitable. Sandra Hewitt said it was reasonable. I was emotional, and I used it to make the wrong decision. In the second life, I sit across the mediation table from David Price on December 3, and I am the least emotional person in the room. This is not because I have no feelings about this. It is because the cold certainty doesn't leave room for emotion to destabilize it. I know the number. I know what's in the estate. I know what we can prove and what we've already proven. Katherine Chen is next to me, and Dr. Vasquez's report is on the table, and the February 12 email is in my memory, and I am very composed. David Price opens with 49%. Katherine Chen says our position is 54%, 5-year alimony at 10,000 monthly, and 290 in sanctions. He says we're not going to agree to sanctions in mediation. That's a separate motion. She says the motion is filed. We can resolve it in mediation or litigate it. Our preference is to resolve it. He says 49% is a very significant offer. Your client would be walking away with approximately 2.7 million. She says, our client would be walking away with 54% of a marital estate she contributed to for 12 years, with 5 years of alimony, during which she reestablishes her professional trajectory, and with reimbursement for legal fees incurred as a result of the opposing party's deliberate interference with her counsel selection. He says that characterization of the Hewitt situation is contested. She says the court will characterize it. We're comfortable with that. He is quiet for a moment. He says, what would it take to close today? She looks at me. I nod. She says, 54% of the full estate, 10,000 monthly for 60 months, and 290,000 in fees. Close today. He says, I'll need to confer with my client. He leaves the room for 45 minutes. Katherine Chen and I sit at the mediation table, and the mediator makes small talk that neither of us fully engages with, and I look at the window, and I wait. He comes back. He says, my client will agree to 54% of the full estate as valued in the Vasquez report, full alimony at the requested amount for 60 months, and 290,000 in fees, to be paid by Vance and Kellerman LLP rather than Mr. Vance personally. I say nothing. Katherine Chen makes a note. She says the firm pays the fees. He says the fees stem from firm-level conduct in the Hewitt referral arrangement. The firm accepts responsibility. Katherine Chen looks at me. I say, we accept. There is the settlement, and then there is the night before the settlement, and they are not the same thing. On December 2, the evening before the mediation session, Katherine Chen calls me to go over final position and to confirm our parameters. The call takes approximately 30 minutes. At the end of it, she says, the discovery documents, the full production. I'm sending them to you tonight if you want to review them before tomorrow. Some of the Vance and Kellerman emails, the ones Judge Finelli ordered produced. There are some you haven't seen yet. I want to make sure you've had a chance to read them, so nothing comes up in mediation that surprises you. I say, send them. The email arrives at 8:07 p.m. I am in the Charles Street townhouse at the kitchen table, with a glass of water and the particular quiet of a December evening, the heat clicking in the old radiators, the street outside doing its late evening thing, the reduced but never fully absent sound of the West Village on a Tuesday night in winter. I open the folder. There are 47 emails in the production. I have read 31 of them already in meetings with Katherine Chen in the context of building the case. The remaining 16 are those that Judge Finelli produced after the in-camera review, which arrived in a separate tranche that I have not yet gone through personally. I start from the beginning. I read in order of date. The March 3, 2021 email, which I have heard read aloud, is active as of today. Transfer timeline, August. The HH recommendation should wait. The March 14, 2021 email to Warren Alden, subject line a timing. Let's not move too quickly. The fiscal year end makes the most sense. Once the transfer is on record, it's clean. The April 7, 2021 email, an exchange about the property appraisal, the appropriate value to use in the transfer documents. The August 18, 2021 email subject line, Suffolk filing tomorrow, transfer clears tomorrow. Clean. Thanks for covering the admin side. I owe you lunch at the club. I read through the summer and fall 2021 emails, the ones about the LLC's banking setup, about the Wyoming entities, about the deferred comp structure. These are detailed and specific, and they tell the story of a man who understood exactly what he was building and was building it carefully. There is no ambiguity. There is no interpretation required. The emails say what they say. I reached December 2022. A gap in the production, 6 months with no relevant communications, which makes sense because nothing significant happened in those months. Then February 5, 2023. Gregory to Warren Alden, subject line thinking. The body of the email is 2 sentences. The first sentence is, I've been running through the numbers, and I think if it comes to it, we're looking at about 3 to 3.5 with HH managing Discovery. The second sentence is, she's not going to push. She never pushes. I read this. I read it again. He was thinking about it on February 5. 6 days before I told him I wanted a separation, he was running through the numbers. He had been thinking about the ending of the marriage, not grieving it, not avoiding it, but calculating its parameters, before I had said anything to him. He knew before February 11. The February 12 email, she's still emotional from the conversation, describes the conversation I started. But the planning had started before that. The thinking email on February 5 shows a man who was already somewhere in his evaluation of this outcome, already identifying HH as his mechanism, already modeling the financial result he expected. I sit with this for a long time. The grief I did not expect to feel, and it is grief, a specific and strange kind of it, different from the grief of separation, different from the grief of loss, is the grief of learning how early it started. February 5. I did not know on February 5 that the marriage was ending. I was not certain it was ending. I was in the difficult middle space of a person who is living inside something that is no longer working and hasn't yet decided what to do about it. He had already decided. He was already accounting for it. The February 12 email I reached next. Subject line, preliminary assessment of exposure. I read it in full without Katherine Chen's intermediation, just the text on the screen in a house that is very quiet. The paragraph about me reads, she's still emotional from the conversation. I don't expect her to retain sophisticated counsel. If we move quickly on the 8H recommendation, we control the process. I do not feel rage at this, which surprises me. I feel something more like the completion of a thing I have been waiting to feel for a long time, in both lives, across 15 years of the first and 9 months of the second. The completion of understanding. The arrival at the precise nature of what was done. He did not hate me. That is what's strange and, in its own way, harder than hatred would be. He did not plan this out of malice. He planned it the way he planned everything, methodically, strategically, with the same intelligence he brought to his cases. I was a variable in his calculation. He identified my vulnerability, my likelihood to seek ordinary counsel, my emotional state in the immediate aftermath of the conversation, and he moved quickly to use it. I was managed. I was a problem to be controlled, and he controlled it. The final email in the production is dated March 3 of this year, 9 days after I retained Katherine Chen. It is from Warren Alden to Gregory, subject line, Chen conflict check result. The body reads, just got the call from the partners. Chen's blocked. Conflict entry from the 19 matter. They can't take sides in anything connected to you. Bad timing. If the Ellison filing names us, we're without our best expert. And then in Gregory's reply, time-stamped 40 minutes later, how did she know to go to Chen? How did she know to go to Chen? He never found out. I never told him, and Katherine Chen never told him, and there is no discoverable fact that explains it except that I chose carefully. He doesn't know why I chose well, and he doesn't need to know. The why is mine. I close the laptop. I sit at the kitchen table in the December quiet, and I look at the wall in front of me, where the kitchen calendar has December's photograph. A winter field, frost on brown grass, a pale sky. The image is ordinary. The light from the lamp on the counter is warm and familiar. 12 years. And before the 12 years were even over, he was running through the numbers. I think about the person I was on February 5, before I knew we were ending, when I was still inside something I was trying to decide about. I think about that person not knowing. I think about how thoroughly I did not know. There is something I lose reading these emails that I didn't expect to lose. Not the marriage. I lost the marriage twice, and I know it. What I lose, reading these emails on December 2 in the house that is mine, is the last version of the story I had been able to tell about the 12 years. That it was real until it stopped being real, that it was something before it became a strategy. February 5 took that. He was already running numbers on February 5. I sit with this for a long time. The radiator clicks. The street is quiet outside. The frost field on the calendar doesn't change. Then I close the laptop. I wash my glass. I turn off the kitchen light. I go upstairs to bed. Tomorrow is the mediation. I am prepared for tomorrow. The settlement documents are signed on December 18. Not in the mediation room. The mediation session in early December was the agreement in principle, but in the formal signing at the courthouse, in the presence of the clerk, with Judge Finelli's signature to make it final. Katherine Chen and David Price are present. Gregory is present, seated at the opposite end of the table, in a suit that costs more than my monthly rent did in the Jersey City apartment, looking exactly like what he is, a very competent man who has lost something and knows it. I look at him once when we enter the room. He looks at me for a moment and then looks away. His expression is controlled. There is something else in it that I can't name precisely. Not regret, exactly, and not grief, and not the cold calculation I have come to associate with him in the long months of this proceeding. Something more like recognition, as if he has looked across the table and seen something he didn't expect to see. I sign the documents. My name is Mara Ellison, and I am 38 years old, and I am signing my name to an agreement that gives me 54% of a marital estate, valued at $5,412,000, 5 years of alimony at $10,000 a month, and $290,000 in legal fee reimbursement from Vance Kellerman LLP. $1,850,000 in the initial disbursement, after the various calculations and adjustments, plus $600,000 in alimony over 5 years, plus the $290,000 in fees already paid by the firm, which means they effectively funded my legal representation from their own accounts, which I find appropriate in a way I cannot fully articulate. The total is not a revenge number. It is a correct number. It is the number that should have been reached in the first life, if I had been properly represented, if Sandra Hewitt had done her job instead of working for the other side. It is not more than I should have. It is what I should have had. Katherine Chen shakes my hand when we are done. She is warm about it, in the measured way of someone who handles success professionally. She says, this was a good result. I say, it was the right result. She smiles briefly. She says those are sometimes the same thing. After the signing, Katherine Chen and I walk out of the courthouse together, and we stand on the sidewalk for a moment, in the December cold, the particular gray cold of New York in mid-December, and she says, how are you doing? I say, I'm doing fine. She says, that's an unusually calm response for someone who just finished what you just finished. I say, I think I had a lot of time to prepare for this. She looks at me, not the look of someone who is satisfied with a non-answer, but also not the look of someone who will push for a better one. She has learned over the 9 months of this proceeding that I operate with a particular relationship to what I disclose and what I hold, and she has come to respect the line without needing to know exactly where it is. This is one of the things about Katherine Chen that I am, in a way I find difficult to fully express, genuinely grateful for. She says, I want to say one thing. You were the most prepared client I have worked with in 20 years of practice. Not in the sense of having documents ready, though that too, but in the sense of knowing what you didn't know and knowing what you needed to find out. That's unusual. Most clients either know too little and are lost, or they think they know too much and they're in my way. You were somewhere different. I say, I had good reason to think carefully about this. She says, whatever the reason, it made the difference. We found things because you knew where to point us. The Alder Point search, the first Meridian lead, those came from you. I want you to understand that. I say, and you did the actual work. She says, we both did the actual work. That's how it's supposed to go. She shakes my hand. She goes back inside. I walk to the subway. On the 4 train going uptown, standing in the particular proximity of a midday subway car, I think about the courthouse on the 70 Twin Street office and the courthouse on December 18, and the distance between them measured in time and in knowledge and in what was done differently. A woman sitting across from me is reading something on her phone, her expression the focused neutrality of someone in transit between 2 parts of a day. 2 men near the doors are talking about something involving a building permit. The subway does what it does. The bar complaint against Sandra Hewitt, filed with the Attorney Grievance Committee on October 14, is pending as of the settlement date. I am told by the intake officer that the AGC process is thorough but slow, typically 12 to 18 months from complaint filing to resolution. I do not expect a fast outcome. I filed a complaint because the right answer to what Sandra Hewitt did is to make a formal record of it. For the profession, for the next client she might have, for the principle that what she did has a name, and the name should go somewhere official. I am not in the habit of expecting institutions to move quickly, but I expect them to move eventually. In January, I find an apartment on the Upper West Side. It is on the 8th floor of a building on West 84th Street, 2 blocks from Riverside Park. 3 bedrooms, 2 more than I need. But I have spent enough years in a studio in Jersey City to understand that the opposite extreme is a reasonable corrective. The apartment faces west, which means the light in the evenings is the particular gold of the Hudson's sunset, and I know this light, which is not the same as the light I watched from the beige chair in Jersey City, but which has some of the same water in it, the same angle of late afternoon falling across moving water, and I think this is fine, that some continuities are acceptable. I move in on February 3. The movers take 4 hours, and the apartment is, at the end of it, full of boxes and the particular potential of a new space that hasn't yet absorbed the life that will live in it. I put the Hopper reproduction on the wall. I have it in this life, too. I bought it from the same street vendor on the same Sunday when I was feeling the same thing I couldn't name. And beside it, the botanical diagram of the iris and the photograph of the Hudson at dusk. 3 things on a white wall. They look different here than they did in Jersey City. They look like the beginning of something rather than the conclusion of it. Cora comes over on the second evening. She brings wine and takeout from the Vietnamese place on Columbus, and we sit on the floor because I don't have furniture yet, and she looks around at the boxes and the bare walls and the 3 framed prints, and she says, "This is a good apartment." I say, "I think so." She says, "Are you okay?" I think about this. I say, "I'm okay." She says, "That's not an enthusiastic okay." I say, "I'm okay in the way where you've won something, and you're sitting with the shape of what winning looks like." She says, "That sounds a little melancholy." I say, "Maybe. It's also just accurate." She passes me the wine. We eat sitting on the floor of the empty apartment with the Hudson light fading outside the west windows. And she talks about her life, her kids, her work, a trip she's planning. And I listen and I contribute, and the evening is its ordinary self, which is a kind of grace. After she leaves, I wash the takeout containers and put them in the recycling, and I stand at the west window for a while in the dark. Riverside Park is barely visible below, the tree lines leafless in February, the river just visible beyond. The city does what it does at night. The lights, the ambient sound that is never silence, the specific energy of a place where people are always awake somewhere, always moving, always arranging and rearranging the texture of their lives. I am 39 years old. I will be 40 in March. I have the apartment and the settlement and the right number and the case that was won. I have Katherine Chen's handshake and the final document with both signatures and the knowledge, which I carry like a second skeleton, of exactly what happened and exactly how I changed it. What I also have, and I know this now, standing at the window in a way that is very clear, is the February 5 email. He was running through the numbers on February 5. He knew before I told him. He had already identified the mechanism and the expected outcome. She's not going to push. She never pushes. That was his model of me. That was what he thought he knew about who I was. I do not know how to hold this and simultaneously hold the 12 years that were real. The February trips to the farmer's market, the herbs in the terracotta pots, the way he listened when I talked, the way he bought cut flowers because he knew I liked them. I can't arrange these things into a coherent story that has one true answer. The flowers were real. The calculation was also real. Both things existed in the same man across the same 12 years, and I cannot tell which one is the true version of him and which one is the performance, and I suspect the answer is neither. The answer is both. The answer is that people can be real and calculating simultaneously, that the listening and the planning were not mutually exclusive, that Gregory Vance was a person who loved me, in his way, for parts of 12 years, and was also someone who, when it came to it, chose to win over protecting me. This is the thing that doesn't get better. Not with the correct settlement number, not with Katherine Chen's handshake, not with the apartment on the Upper West Side, or the Hudson light through the west windows. The grief I feel is not for the marriage ending. It is for the calendar on the wall, February 5, and what it means about the shape of a thing I thought I understood. I believed for most of the 12 years that he was someone I could trust. That belief was not entirely wrong, but it was not entirely right either. And the cost of being not entirely right about something that important is a bill that gets paid in the currency of time, which is the only currency that doesn't refund. I am 39. I am in a new apartment in February. The settlement is signed. The bar complaint is filed. The work is done. On the first Saturday in February, I wake up early. The apartment is still mostly empty. I make coffee in the kitchen. I am still learning. The cabinet placement, the light switch on the wrong side, the particular sound the espresso maker makes. and I bring it to the west window, and I sit on the floor with my back against the wall, and I watch the light change over Riverside Drive. The light comes slowly in February. It starts with a gray distinction between the sky and the tree line, and then the sky begins to separate into colors. The blue of very early morning, the faint line of pink on the eastern horizon that you can't see from this window, but whose reflection you can see in the glass buildings across the river in New Jersey. It takes about 40 minutes to go from gray to fully morning. I watch all 40 minutes. I think about the studio apartment in Jersey City, the fourth floor, the beige chair, the radiator that knocked twice an hour. I think about the Hopper reproduction on that wall, and the morning of the heart attack, the left arm, the pain moving to the sternum, the phone 2 feet away that I couldn't reach. I think about the moment when the chair and the light and the carpet the color of old cream were not there anymore. I think about waking up in the West Village townhouse at 38, the smell of cedar and leather shoe polish, the West Village morning through the linen curtains, the ceiling with the water stain in the shape of a question mark or a reaching hand. I think about April 22, Katherine Chen's office, Park Avenue South, the real plants in the reception area, the way she said, "Tell me everything you know, not what you can prove. Everything you know." I told her everything, and she found the rest. The light is fully morning now. The river is silver gray and moving. A runner is crossing on Riverside Drive, the compressed rhythm of someone who has been doing this long enough not to think about it. Two pigeons on the window ledge of the building across the street. A taxi moving south. The city is doing what it always does, which is everything, simultaneously, without caring whether any individual within it is winning or losing, or somewhere in the long middle of figuring it out. I am 39 years old, and I am in my apartment, and it is morning, and this morning is mine. I don't celebrate this. Celebrating feels like the wrong response to something that is simply correct, a thing restored to its proper position rather than a thing newly gained. I sit with the coffee and the light and the ordinary enormity of a morning that belongs to no one but me, and I feel the shape of it. The bar complaint is pending. The bar complaint will take time. I do not know what will happen to Sandra Hewitt, whether the profession will register a complaint and issue a formal consequence, or whether the institutional mechanisms will move slowly enough that it comes to nothing. I have done what I can. The record exists. I do not know what will happen to Gregory. He will continue his career, I expect. These things rarely end careers outright, and Gregory is too skilled and too established for one bad case to define him. What I know is that within his firm, in the conference rooms and the partner meetings and the internal conversations that constitute the air of a place like Vance and Kellerman, the story of this proceeding will be present. He will not speak of it. Neither will David Price. But it will be there, in the way that outcomes that went wrong are always there, absorbed into the institutional memory of a firm, becoming one of the things known about a person without being said. Whether that matters to him, I genuinely don't know. I have spent 9 months being certain about what he did and how to counter it, and in that certainty I have not often stopped to think about whether he feels anything about how this ended. The February 5 email, "She's not going to push, she never pushes," is what I keep coming back to, not with anger, with something more like curiosity. He was wrong about me. I want to know if he knows he was wrong about me or if he has filed this result under something else. External factors, bad luck, the particular run of legal decisions that didn't go his way. I don't know. I will not ask. These are questions that belong to the interior of a person I no longer have access to, and that is correct. I drink my coffee. The runner on Riverside Drive has passed, and there is another one now, or perhaps the same one coming back, I can't tell. The light is fully morning, and the pigeons are still on the ledge across the street, and the river is the particular February gray that will turn blue in an hour when the sun is higher, and I am in my apartment on West 84th Street, and I am 39 years old, and the morning is mine. I get up. I go to the kitchen. I wash my cup. I think about breakfast. I think about what I need to do this week. There is a campaign brief at MedAxis that needs my attention. There is a coffee with Cora on Thursday. There is a call with the real estate agent who is helping me think about furniture, because I cannot sit on the floor forever, though part of me is not yet ready to stop. Because sitting on the floor in the empty apartment has felt, in these first weeks, like the right relationship to a new place, humble, undecorated, provisional in the best sense. There is a version of this ending that I did not allow myself to reach for, and I want to name it, because it exists in the space of what winning looks like and what it doesn't look like. The version I did not reach for, the one where the settlement number is the vindication, where $1,850,000 is not a correct accounting but a form of retribution, a balancing of a wrong by the conversion of the wrong into currency. I have met people who live in this version, people who have been through contested divorce, who have won significant settlements, who have turned the settlement number into a kind of proof of value, a validation they carry into every subsequent room. I understand the impulse. The impulse is very human. It is also, I think, a trap. The money is correct. It is the right number. It is not and cannot be a restoration of the 15 years of the first life. It is not a refund for the studio apartment or the beige chair or the October heart attack at 53. It does not return to me the person I was at 38 who did not know what she was about to lose. The money is what I was owed for my share of a marriage I co-built and co-sustained, and I have it now, and it is right, and it is also simply money, a resource, a capability, a set of options that I would not have had without it. It is not healing. Healing is not a financial product. What I have, in addition to the money, is the knowledge that I did not accept less than I was owed. In the first life, I accepted less than I was owed because I did not know the full amount, and because the person paid to tell me was working for the other side, and because I was sad and tired and the 64 hours of Sandra Hewitt's billing had not produced anything that gave me the standing to ask for more. I signed. I moved to Jersey City. I watched the Hudson from a beige chair, and I knew something was wrong, and I never had the language for it. In this life, I have the language for it. I have the documents that produced the language, and the attorney who knew how to read the documents, and the forensic accountant who traced the transfer chains, and the Wyoming entities, and the First Meridian accounts, and the judge who ordered the emails produced, and the settlement agreement with both signatures. I have all of it. What I do not have, and will not have, is the version of the 12 years that does not include the February 5 email. That version does not exist. The 12 years include the February 5 email and the Italian restaurant on Bleecker and the car through Queens in the dark and the tulips at the farmer's market and the HH recommendation and Alder Point Holdings LLC and the East Hampton house and the October apartment in Jersey City where I died in a chair alone. All of it happened. All of it is true. I hold it in the way you hold something very heavy for a long time, not burdened by it exactly, but aware of the weight, aware that the weight is real and that I am carrying it correctly now, which is a different thing from not carrying it at all. I make eggs. I eat them at the kitchen counter because I don't have a table yet. The kitchen faces east, and the morning light is coming in the kitchen window now, the one that looks down on 84th Street, and it is the simple, direct light of a winter morning. No softening, no distance, just the cold, clear light of early in the year falling on the counter and the cup and my hands. I wash the plate. I dry it. I put it away. Outside, the city continues. I am in it and of it, and I am also here in this apartment, in this light, correctly placed. Cora calls on the second Saturday. She says, "What are you doing today?" I say, "Unpacking, probably." She says, "Do you want company?" I say, "Not yet." She says, "Okay." She doesn't ask why not yet. She knows why not yet. This is the specific grace of a friendship long enough to have developed its own grammar. I think of the question mark on the ceiling of the West Village townhouse, the water stain, the shape I could never quite determine. A question mark or a reaching hand. I think I know now what it was. It was a question mark. And the question was, what do you do with the knowledge of what was done to you? The answer is this. This exactly. You find the right attorney. You do the work. You sign the documents and you take what is yours. And you do not let the taking make you someone who cannot live without it. You move to a new apartment. You watch the light change in the morning. You wash your cup and dry it and put it away. And then you begin. End of the retainer.